let's continue. Switch on your mic.
Listen, Ngui, we broke at the stage where you were saying you'd now been suspended and then recalled. What happened? Oh, sorry, you'd been dismissed and recalled. Then you were suspended.
That's correct, Chair.
And how long did that suspension last?
The suspension lasted for 3 months.
What were you told was the reason for your suspension?
The reason for the suspension was the insolence.
The same
Yes, as
issue.
the letter, yeah.
And that was stated in the letter of suspension?
Yes, it was stated in the
Okay.
letter.
And how is it that you came back to work?
Chairperson, Mr. Montana left in July, right, end of July. So we came back in about August, where the board had appointed an acting CEO, Mr. Nathi Khena. What I understand transpired was the board had instructed Mr. Nathi Khena to look into the matters that Mr. Montana had been dealing with, especially around the suspensions, and to make sure that he deals with all those and finalizes the suspensions. What then transpired, where I'm concerned, is that I received a call from Mr. Nathi Khena wanting to talk to me about the issues that had been raised relating to my suspension. But what was interesting, Chairperson, in my case, was that after Mr. Montana had left, there were charges that were preferred against me. Those charges included me having authorized 2 contracts, effectively, during the tenure of my CEO role, of about 10 million rand in one respect, and the other one was 59 million rand. So as part of the investigations that Mr. Khena conducted, was inclusive of that. And I understood from him that when he sought evidence from, the colleagues internally, including people from HR, the CEO of Prasa Rail at the time, because those contracts were impacting that business, they indicated to him that they were not sure of what, Mr. Montana had alluded to in the charges. So, I mean, nobody could give evidence as to, what's the word I'm looking for? The charges that were laid against me. And after that, Mr. Nathi Khena questioned me around those particular contracts. And obviously I didn't even know, the 10 million. I didn't even know that I had even dealt with the 10 million. And the other one, I had an explanation to give to him as to what had transpired. And it was not an authority that had been given by me, It belonged to another business unit. So on that basis, he then decided to say, look, I can't find evidence that pinpoints to you having done any maladministrations or wrong things as far as those contracts are concerned. And he asked me to come back.
Mr. Montana left on the 15th of July.
Yes.
Before he left, you were already on suspension.
That's correct.
But had you been told before he left what charges you were going to face or were to be brought against you?
I wasn't told, Chairperson.
There had been no communication at all since your suspension, other than the letter telling you about your suspension?
There had been none.
There had been nothing. And nobody had phoned you to speak to you and tell you what was going on in terms of any investigation about your suspension?
Nothing, Chairperson.
Yes. And the issue of the 2 contracts, you only became aware of it when?
When I saw the draft charges that were sent to me.
Were you ever given draft charges, or did you simply see them when the acting GCO, is it Mr. Khena?
Mr. Khena, yes.
Mr. Khena was talking to you, investigating what had happened?
just before Mr. Khena had been requested to act, I think it's a day or two before that, I then receive, these charges. He obviously did not know about them, and that's why he needed to investigate those charges.
Who had signed the charges?
They were not signed, Chair.
Were they in final form? Were they draft charges?
They looked final.
What was their status?
They looked final, but they were not signed. They were not signed.
Who gave them to you? How did they reach you?
An ER manager.
And what's an ER manager?
Employee relations manager.
Yes.
Within HR. His name is Mr. Sillo Maluleke.
Yes. He gave them to you.
He gave them to me. In fact, he sent them via my email address.
And did he say anything about them to you?
No, nothing was communicated.
He just sent them to you?
Yes.
Oh, and it didn't indicate for what purpose they were being sent to you?
No, I just received them in my email box.
Yes. Did they indicate a date a date for the disciplinary hearing?
No, they hadn't. They hadn't indicated a date.
Yes. And after receiving them, did you speak to anybody about them or to the one who sent them to you?
The one thing that I said to Mr. Maluleke is that I believe I will engage the services of an attorney, of an external attorney, should this matter proceed. That's all I said.
Now, did the charges relate only to the two contracts you are talking about, or did they include the allegations of insolence?
No, they were only in respect to the two contracts. So my suspension letter did not accord with the charges that were leveled against me. So when I looked at the two, I thought, but this is not what I was suspended for, if anything.
Okay, thank you.
Yes, please. Just to complete the picture, what happened to Mr. Dingiswayo?
As far as Mr. Dingiswayo was concerned, because Mr. Dingiswayo reports to me, what Mr. Khena said to me is that you are going to have to deal with these allegations that were leveled against Mr. Dingiswayo. And Mr. Dingiswayo's return to work was subject to him not being found wanting as far as the allegations was concerned. What Mr. Khena also did is that he requested our internal auditor, Mr. Rashik Zaman, to look into, the issues that were raised in Mr. Dingiswayo's letters and to advise accordingly. And, Mr. Zaman could not find anything untoward that Mr. Dingiswayo had done. Because also Mr. Dingiswayo's letter was very vague in terms of the issues that were raised there, that he's busy talking to the board and leaking information to the board. He didn't know the specificities of those issues. So I guess it became very difficult to pinpoint what exactly he was accused of.
Okay.
Well, it indeed would be strange, and I'm making a comment, that if somebody passes information to the Board of Control of an organ of state, that person would be charged with misconduct.
That's correct, Chair. I mean, it was something we didn't understand, and we didn't understand how you leak information to the board. It just didn't make sense.
And about when did he return to work?
Mr. Dingiswayo returned at the same time that I did, which was in August. In August 2015.
Okay. Do you remember the date by any chance?
I think around about the 15th of August,
Okay.
2015. Yeah.
Now, you'll recall that Mr. Dingiswayo's dismissal and then your dismissal on the following day followed the email at SS7B, page 317. That's the email you read into the record, you recall that?
That's correct, Chair.
And that, you say, that email was prompted by advice you and Mr. Dingiswayo had given in regard to the Swifambo and the Prodigy contracts.
That's correct, Chair.
Now, just in relation to those contracts, and just in this part of your evidence, what is the status of those?
We are still in litigation with Prodigy, Chairperson, And Sifambo, I guess, has been dealt with by the courts and it has been finalized. But the prodigy matter is still in litigation. It has not been finalized.
Is there evidence that Mr. Montana rejected your advice that the two contracts were problematic?
Yes, Chair.
Yes.
Chair, I started by saying, there were some areas within the organization that appreciated the work that the legal function was doing. But obviously those that were not interested in complying with the laws and so saw us as a nuisance to the organization, and we were just treated as such.
Who are some of the people that you believed treated the legal department as a nuisance?
Well, Chair, Mr. Montana obviously being one, and I'm talking about people in authority here.
Yes.
And I remember also during Dr. Popo Molefe's tenure, there was a chairperson of the audit committee, for instance, I forget her name now, who had also, taken issue with the fact that we had challenged her decision to incorporate, in fact, wanted to incorporate another party into a contract, and we found it not to be proper. And when we raised our objections, they took serious issue with us. So there's quite a number of people, even after Mr. Montana had left, that you found that the people in authority did not appreciate the advice that we gave. Some board chairpersons, they didn't. To the last board chairperson, to the last board that was at PRASA, we gave myriad of advice, and they just didn't like the advice that we were giving.
The people that you're talking about that you put under this category of people who thought who acted in a manner that made you think that they thought that the legal department was a nuisance. Obviously, you don't think that where they disagreed with the legal department's views or suggestions, you don't think that they were acting in good faith, or were they acting in good faith but just didn't agree with you?
No, the good faith was not there, Chairperson. For me, it is one thing to disagree, with somebody, and from an opinion perspective, we can disagree about what the outcome of the opinion is. But, in most instances, really, we found that there was mala fides, in fact, where we gave advice, and they just did not like the advice that we would have given. And in fact, in many instances, we were ostracized as the legal department and not engaged when we ought to be engaged. So the people really internally that appreciated us were, our colleagues in the business that would know that we need the legal team to assist us with certain matters and so on. But what we found is that the authorities in the organization did not like it if we told them things that they didn't like.
A department such as a legal department is supposed to be a helpful department.
That's correct.
To give advice and guidance to everybody to make sure that things are done legally.
That's correct.
Why would this category of people not have appreciated this important role of the legal department?
I don't know, Chair, and it was really frustrating for us, because I think what we were trying to do as the legal department, and what we continue to do as the legal department, is to look out for the interests of PRASA. All we do is that. And if there is a way of achieving a particular end, we advise the organization accordingly. So we don't just say, this cannot be done and that's it. We then advise of a manner in which, we can achieve the same results. But, we found that at various instances, the legal department would just be excluded, because we just complicate things. They would say we complicate things. Yeah.
When it was excluded, was there an alternative place to which people went to get legal advice instead of the legal department of PRASA?
Well, yes, Chair, I can think of instances where, in one of the instances where we were dealing with the chairperson, Makubela, she went to another law firm, which was also not on our panel. and got advice there to the exclusion of the legal function. So, I guess they would do it, as they pleased.
Is your answer that sometimes they did, sometimes they didn't?
That's
namely
correct,
go
Chair.
elsewhere?
Yes, Chair.
Okay.
Just on the question of good faith and disagreements, or the difference between those two. In the Swifambo matter, in which there were investigations done before the matter was taken to court, what was the position in regard to documents that would assist in determining what had happened and the validity of the different steps taken?
Chairperson, the issue around information at PRASA is a minefield. Effectively, there isn't proper record keeping where PRASA's document management processes are concerned. We don't have a document management system. So effectively, at the time that the investigations were being conducted, it was a real tall order to find information from people. And I guess, people were scared, I guess, for lack of a better word, as to what would be found where they are concerned, such that the part of the investigation process was to take all our computers and image, the computers so that information can be retrieved in that manner. But however, if one went out to ask for documents from a particular area within the organization that you would have expected to be retaining that documentation, it was very difficult to find information.
And when, for example, in the Swifambo matter, and we'll come to that in regard to the Siangena matter, were you able to piece together what had happened, what decisions were taken, what they were based on the basis of proper records?
Yes, Chair. Eventually, we were able to get information that allowed us, as part of the investigation process as well, because the legal function was instrumental in trying to assist the investigators in getting information. So we were able to then, understand what had transpired and look for the documents, in the right areas, because before, everything was everywhere and we didn't know where to find them. So
that's in regard to Swifambo.
That's correct, Chair.
And with regard to Siangena, which we'll get to in a moment?
Siangena was very difficult. It was very difficult to the last affidavits that we had to do. People did not want, employees within PRASA really did not want to be associated with assisting the organization in dealing with the issues pertaining to Siangena. In fact, there were very few of our colleagues that agreed to participate in giving affidavits and confirming what had transpired in relation to these contracts when they were involved. But it was very difficult. People, I guess, were just not wanting to assist, and it's been difficult, really. And I think it continued to be difficult right until the last affidavits that we had to file. So I guess, Chairperson, what I'm trying to also say is that because these investigations had identified a lot of people, in terms of maladministration and irregularity, people just didn't want to participate at all.
So we'll come back to the Siangena matter, which you deal with in your third affidavit, which is SS7C.
Yes, Chair.
In the meantime, though, can we return to the affidavit that is SS7B and turn to the next topic you deal with, and that is Mr. Mabunda and the SOCIA group of companies.
Yes, Chair.
Firstly, could you tell the Chairperson very briefly why Mr. Mabunda turns out to be such a significant figure in process operations?
Chairperson, Mr. Mabunda had, there were a lot of contracts, I must say, that he managed to, be involved in where PRASA was concerned, especially in the engineering department of PRASA. I mean, he, as far as I can remember, you know, the signaling contracts of PRASA, the you know, depot design issues of PRASA and all those critical contracts, Mr. Mabunda was the company that was involved. In fact, in this particular instance, what one found was that when they sued us for 6 contracts, separate, where they had been doing different types of work within PRASA. So, you know, it is somebody that we knew at PRASA to have a lot of, you know, attention actually when he comes to PRASA. And he was very also influential at PRASA. Whenever he came, you know, people would talk about him. That's Mr. Mabunda there, he's coming. And he would be given the attention that he needed. So it's somebody that we knew was obviously an important person within the organization that was treated, you know, with that kind of respect.
Had you known of him even before you headed the legal department?
No, I didn't know of him, Chairperson.
You only got to know of him when you got to the legal department?
That's correct, Chair.
Okay. You say he had a lot of contracts.
Yes.
You want to give me an idea of
Well,
more or less how many contracts, even if you are not able to specify, give them names?
if I can say, Chair, it's more than 7 contracts, and major contracts that Mr. Mabunda had. In fact, the investigations revealed that the amount of money that had been paid by PRASA to the S group of companies where Mr. Mabunda was concerned was close to R1 billion at a particular point. So there was a lot of work that he was doing.
Okay.
And do you know whether he played any role in this Refambo contract?
Yes. Yes, Chairperson. In fact, he did play a huge role in this Refambo contract because what we understood was the company, he was a director of the company, Refambo. Yes, so that too, you know, was one of the big contracts that he was involved in. And we knew that, even though at the end of the day, Mr. Mashaba, Oswald Mashaba appears to be the person that was, you know, instrumental. But from the structure of the company, Mr. Mabunda was the person that was the owner of Refambo.
Now, you say that in all, the S group of companies were paid nearly R1 billion by PRASA for different contracts.
Yes, Chair.
But there is one small group of, there is one group of contracts that was the subject of litigation between PRASA and the S group.
That's correct, Chair.
What was the nature of the dispute?
The dispute revolved around work done and not paid for. So naturally, you know, the contract, the scope would be set up to say this is the scope of the contract and this is what you are limited to. But what we then found, because remember, as the legal department chairperson, we get information from the business. What we had found is that the business was saying the work that was done by the S group of companies was not authorized. And in certain instances, part of the litigation that the cases that they were suing us for was there was a dispute as to the amounts that they were paid. So there were various elements of these various contracts. And immediately after Mr. Montana left, the 6 summonses came from CIA in relation to these various contracts that they had been doing for PRASA.
I'm sorry, I didn't hear the what came.
I beg your pardon, Chair?
Didn't hear this first part of your last sentence. You said as soon as Mr. Montana had left, what happened?
The litigation. So the summonses, we just received a barrage of summonses.
Yes.
After that, and
Yes.
it was all coming from, you know, CIA.
Yes. Why had the summons not been issued while Mr. Montana was there?
We don't know, Chair. I mean, you know, because these issues obviously had existed at the time that Mr. Montana was there.
Yes.
But immediately after he had left, 6 summonses arrived at PRASA.
But who was going to issue instructions as to the issuing of the summons? Was it, did it have to be the GCEO?
Well, remember they're coming from CI's side, so CI is suing us.
They were coming to.
That's it,
They
to
were
PRASA.
against PRASA.
That's it. So
okay.
CI was suing us for payment of services they said they rendered
okay.
and so on.
Okay.
Now, prior to the issue of these summonses on PRASA, had there been any legal disputes between CIA or any disputes that ended up in courts between CIA and PRASA?
There hadn't been any, Chair.
Now, what were the amounts involved in respect of these 6 summonses?
It was various amounts, Chair. The total, I don't have the specific details. The total would amount to about 56 million that CIA was suing us for.
Now, if I ask you to look at MN4, which you refer to in
Is that at page 322?
As you please, Chairperson, yes.
Yes. Okay.
You refer to that at paragraph 35 of this affidavit. Is this 7B?
Paragraph 35.
Yes.
Yes, Chair.
You've read that document.
Yes, I have, Chair.
Does that fairly summarize what the nature of the disputes between the CIA group in respect of each of the contracts was and PRASA?
That's correct, Chair.
Now,
Well, let's give more details about MN4. It's a letter, from whom it was, to whom was it addressed, what was the date, what was the subject matter.
as you say.
Before we leave it.
What is MN4, Mr. Ngoyi?
Chair, MN4 is a letter that we received from our attorneys who were acting for PRASA in relation to all those contracts. Diale Makhashwa attorneys were the attorneys on brief that had assisted PRASA in relation to all those contracts.
And
I'm sorry. Diale
Makhashwa
was that PRASA's attorneys?
It was PRASA's attorneys.
Oh, okay.
So when they prepared this document, they had prepared the document on the request of the chairperson.
Yes.
Who wanted to know what had transpired
Yes.
in these matters. So this was a summary to the chairperson to say this is where the matters are and this is what
Yes,
PRASA believes are the chances of success.
And what date is the letter?
The letter is dated 21 November 2017.
Yes. It's addressed to PRASA House and the email Fani Tingiswayo. Is that right?
That's correct, Chair. It's addressed to
Yeah, for the attention of Mr. Fani Tingiswayo and
Mrs.
Mrs. Shumi Mukodeti.
Mukodeti. That's correct, Chair.
Yes, and the subject is report on progress on CIA files. Is that right?
That's correct, Chair.
Yes. Okay.
And in essence, the attorneys summarize what the nature of the disputes is in respect of each of the cases that were now before court.
That's correct, Chair.
May I ask you, were the matters to be eventually, were the matters to be resolved by the courts or were they to be resolved by some other tribunal?
Chairperson, the parties agreed between us and CIA, we agreed to refer the matters to arbitration. And that was one process that we had agreed to, because after the summonses, we came together and agreed that we rather deal with these matters through an arbitration process. And the agreements provide for that dispute resolution mechanism. And so the matters were then referred to arbitration.
Now, in regard to, for example, the Sufambo matter, PRASA had challenged the validity of the contract and therefore asked the court to review and set aside the contracts.
That's correct, Chair.
In regard to the CIA disputes, was it simply a matter of disputing the amounts claimed, or did it go to the heart of the contracts?
Well, it was just around the monies claimed and the services rendered, Chair.
And that is why it was possible, or it was acceptable, that the dispute be arbitrated.
That's correct, Chair.
The dispute about the amount claimed was PASA's contention that there wasn't work that had been done which justified that claim.
Yes, in some of the cases, Chair,
Some of the cases.
the instruction that we received was that no, these monies have been paid.
Yeah.
You know, we don't owe CIA any monies.
Yes.
And in others, that we were told that no, they did work that they were not authorized to do. And obviously, the colleagues were feeling that it was, because it was beyond and there were no variations to the contract, they just felt that it wasn't proper to just, pay CIA in relation to those matters.
Okay.
The dispute with CIA started while Mr. Molefe's board was still in office.
That's correct, Chair.
And at the time of this letter at MN4, the 21st of November, what was the status of Mr. Molefe's board?
Mr. Molefe had left. The board of Mr. Molefe had finished their term. And so there was a new board that was present at that time. So this letter was effectively to deal with the inquiry that was coming from the chairperson of the new board, Ms. Makubela.
Now you deal with that at paragraph 32 of SS7B, and you set out the date of the new board and so on. Are those all correct?
That's correct, Chair.
Yes. Now, after this dispute became known to, soon after she was appointed to the board, what was the interaction between you and Ms. Makubela?
Chairperson, my first interaction with Ms. Makubela was around, my portfolio as legal. And it was also around understanding what had transpired in relation to the worksman's contract, who had appointed worksmen and how it was appointed and so on, because what she indicated to us was that she was required, and also in relation to Parliament, to have to go and explain to Parliament how worksmen was appointed at PRASA. So that was the first really meeting that I had where I explained to her the structure of the legal function, and I advised her that we were not acting at the time. And so, that really it was a short meeting with Ms. Makubela.
And in relation to the CIA contracts?
Well, in relation to the CIA contracts, Chairperson, I was called in again by the chairperson, and because I operate at a strategic level, I then called Mr. Dingiswayo, who would have more detail on the matters, to come with me to the meeting so that we can explain these contracts accordingly to the chairperson. And, what became alarming for me in that meeting was, when the chairperson said, at this time, perhaps I must say, Chairperson, the CIA contracts, they had applied for liquidation, right? And the liquidation process was happening. It was voluntary liquidation of this CIA Consulting Engineering Company, which was one of the companies that had sued us. So she said that she had received information from a colleague of hers who sits at the Pretoria bench, and that, we had made, PRASA had made concessions in the liquidation proceedings that warranted CIA to be paid. And she said she had a particular report as well that was talking to that fact. So when we asked for the report, she didn't share it, with us. She said, no, She wasn't supposed to share that report with us. It was for her information. And so therefore she wanted to see how she could best deal with these matters.
What was your reaction? I mean, here's the chairperson of the board dealing with legal matters. How did you react to that? And what was your perception of her receiving information from outside sources?
Chairperson, it's obviously, it's unheard of. You know, for me, it really was unheard of. And I would have thought, my first impression was, you know, try and understand exactly what is happening within the organization. A chairperson can ask any questions and can ask for, you know, explanations. That was not a problem. But to have already made a decision that says, yes, I've got this report and PRASA people had conceded in the litigation, in the liquidation proceedings, and therefore we need to see how we settle these matters. That for me was a concern, you know, because I thought, I'm not sure how far this goes, because as far as I'm concerned, these matters were matters that as PRASA we knew we had defenses. And so I don't quite understand why it is now that we would be now put into a position to settle these matters, and this was driven by the chairperson. So it took me, you know, it took me back, and I thought to myself, okay, we'll have to see how this thing plans out, because I had thought also that the chairperson would work with us as the legal department to make sure that we are all aligned. But that was not to be, chairperson, because she excluded us altogether from you know, the deliberations of this matter. In fact, she preferred to deal with the external attorneys of PRASA in this matter, and not the internal legal function within PRASA.
Would this have been 2016?
2017, Chair.
2017.
That's correct.
Yeah.
Now, there is an issue that comes up. Mr. Montana, as you understand it, didn't have legal qualification. But Ms. Makubela?
Yes, I understood Ms. Makubela to be SC, senior counsel, and yeah. So she definitely had the legal background. And in fact, we were quite excited that we've got a chairperson who is a lawyer, you know, and would help us deal with all these matters.
And so when she asked, we dealt with MN4, and you see that that's dated the 21st of November 2017. That's the report back which the attorneys had given, am I correct?
That's correct.
And which you said clearly reflected what the nature of the disputes were and what PRASA's defenses were to each of the cases.
That's correct, Chair.
What happened next in relation to that dispute?
Well, Chair, as I alluded, you know, the chairperson decided to deal with our attorneys, the external attorneys, as well as the attorneys of CIA. And a form of a settlement agreement, you know, was entered into. I'm summarizing, Chairperson. At the end of the day, what we understood was that, you know, she had given instructions as to how the matters must be settled, you know, and those instructions now needed to be effected. And the next thing we knew as the legal department was that there was going to be an application to make that the settlement agreements, you know, an order of court so that PRASA can pay. But before that, Chair, what transpired is that we then engaged our attorneys, the external attorneys that we had briefed, and we said, look, you seem...
And who were these attorneys?
Diale Mohale.
Oh, same attorneys.
Yes.
Yeah, okay.
We said, because all our attorneys know, Chairperson, that you don't deal with the business without the legal function being present. And we stressed that upon all our attorneys. So, you know, we expressed that concern with the attorneys, and the response we got was something else. I mean, the attorney, Mr. Diale, Mr. Mkhashwa, said to us that he was barred by the chairperson of the board from speaking to the legal department.
And the chairperson of the board at that time was Ms.
Makubela, yes.
Okay.
So we left it at that. So we said, okay, that's fine. But already one could see that there's something amiss with what was happening, and we are very concerned about it.
Mr. Ngwe, before you go on, after she received, or PRASA received, MN4, if you look at your affidavit, you refer to a document prepared by the chairperson.
Yes.
And you'll find that at paragraph 35. And the document you talk about...
What page?
Oh, sorry, Mr.
What
Chairperson.
page?
At page 294 of the affidavit, at paragraph 35, and the annex here is...
Hang
at
on
page,
1 second, 235.
That's right.
One
Sorry,
second.
294.
294.
Yes,
Yes, paragraph 35.
that is so, Chairperson.
Okay.
And then you refer to MN5, which, Chairperson, appears at page 338 of SS7.
338.
338, Chairperson, yes.
Yes.
Now, did you regard this as an important document relating to...
Just let's identify it once again, what document it is,
As-
from
as-
whom
as you
it was,
please,
to whom
yes.
it was sent, and what was the subject matter.
So, first of all, who is the document addressed to?
The document is addressed to Mr. Zide, Mr. Lindikaya Zide, who was the acting chief executive officer at the time.
And from whom is it?
It is from the chairperson of the PRASA board at the time, Advocate Tan Makubele, SC.
And what is the date of the document?
The date is 28th November 2017.
And what is the subject matter of this document?
CIA Consulting Engineers Pty Ltd in liquidation, inquiry in terms of section 4171 and 4182 of the Companies Act 61 of 1973.
Now, in paragraph 36, you refer to a number of concerns that that document prompted. Could you...
Well, I'm sorry, before we go to what it prompted, let's have the gist of what the
Yes.
letter said. Yes.
Chairperson,
Yeah, what was the gist of what that letter was talking about?
the gist, Chairperson, was around the settlement of the CIA contract.
Yes.
I think what the chairperson in this memo advises is that, you know, she had been in contact with the liquidators of CIA who gave her a report, you know, that was a subject of the liquidation proceedings. And also in the memo, you know, she then indicates that she's not sure why our attorneys say that they did not have that report, because as far as she was concerned, the report was available. So, and also in terms of the memo, she speaks to the letter that Diala Mokhashwa had made available to her, because remember, she asked for information, we gave her information requesting Diala Mokhashwa to summarize the matters. So she refers to that report and refers to the subpoenas that our colleagues had received in relation to the litigation. In fact, speaks to the liquidation processes, Chairperson. And then she talks to the report, you know, the interim report of the commissioner, that the witnesses that testified in the hearing, in the inquiry, you know, acknowledged that PRASA owed CIA monies. So this is in a nutshell what she talks to. She talks to that report. She said witnesses made major concessions in regards to the liability of PRASA. So she writes this because she says she needed to have this report ready for the board, and also she was preparing also to go to the portfolio committee.
Before we go on, can I just ask you to look at paragraph 5 of MN 5, which appears at page 339. And will you read into the record what she says were the circumstances in which she acquired this liquidation report?
She says, you are aware that attorneys acting for CIA Consulting Engineers in liquidation approached on or about 14 November, and that they provided me with a copy of an interim report of the inquiry in terms of the Companies Act. That was prepared by the Commissioner and dated 15 September 2017. They also attached copies of email communication between Mr. Madimbe Mohashwa and Mohasha Diale and Advocate Francois Waters, SC. The email communication is also attached in Mohashwa Diale attorney's report.
Now, who is Advocate Francois Waters?
Advocate Waters was acting for, was in the liquidation proceedings. So he was the one that.
But whom was he acting for?
He was acting for CIA.
So, in relation to how Ms. Makubela says she got the information, what was your understanding?
Chair, I was taken aback because the little I understand, at least about liquidation proceedings, is that things like this, you don't just give reports out without necessarily following procedure. So, but also when she said it at the time, she said, because of collegiality, I was able to they gave me this report. So from that onwards, I knew that this was obviously not something that was done properly, especially after inquiring from our attorneys, who told us that they didn't have the report. So, it became surprising how she could then have that report, and as our attorneys didn't have it.
But in terms of communications between her, in looking at what she says and the fact that she refers to the report, from whom did she get the report?
Sorry, Chair, which report are we?
The report she is talking about. The interim report of the liquidator at paragraph 5.
Well, to me, she said it was collegiality. A colleague of hers who seems to be, where they do these type of matters in the Pretoria Bar, had been the person that had given her the report. I didn't quite ask, who that was, but she referred to collegiality, and I just accepted it for what it is.
Well, if you look at paragraph 5, it seems that between the word approached and on in the second line, the word me appears to be missing if one wants to read sense into that.
Yes, that's correct, Chair.
So based on what she is saying in paragraph 5, where would she have got the report from?
She would have gotten it from the attorneys acting for CIA Consulting Engineers. Perhaps, may I also say, she's writing to the group CEO at the time, Stellindi Zide, and perhaps she'd had this discussion with Mr. Zide, and that is why she's saying you are aware, because it's referencing, her discussions perhaps with Mr. Zide. But when I engaged with her, she didn't tell me, she just said collegiality.
Well, if you look at paragraph 36, you suggest something else.
That's going back to her affidavit.
Oh, sorry, Chairperson,
yes.
To her affidavit. At page 294, Ms. Ngoya.
Yes, Chair.
You are saying exactly what that letter says, that she was approached by the attorneys.
Well, yes, Chair. Because that was what was startling for me, as I indicate in the paragraph, that she had been approached by the attorneys of Siangena. And that I get from obviously the memo that she had prepared.
Yes. And after that approach, what had they done?
They gave her this interim report of the insolvency inquiry.
And what does she say about process attorneys in the memo, which you
Let me just
Summarize at paragraph 36.
36. She says that she did not necessarily believe that the PRASA attorneys would not have the report. You know, it's one of the things that she alleges in that memo.
Yes. And then she made the point that she'd made previously, that she was told that PRASA employees had made major concessions.
That's correct, Chair.
Now, what was your reaction to the communication between her as chairperson and the opposing attorney?
Chairperson is unheard of. You know, I mean, I for as long as I think I've been an attorney, one knows what the boundaries are. You know, when you have attorneys on board each side, the attorneys are the ones that speak on behalf of their clients. You know, you don't do it like that. So for me, it was alarming, you know, that here we have a chairperson of the board who is a senior counsel for that matter, you know, who would conduct herself in that manner. You know, it was just something that we frowned upon. But we left the chairperson because we were not wanted in that whole sphere, but we recognized what was happening.
So did you say you were?
Well, you say you recognize what was happening. What was happening?
Well, the fact that now she's communicating directly to attorneys of the other side, you know, to the exclusion of the legal department. She was running with the matter herself, you know, and for us in the legal department, that's not, the chairperson does not have that authority, first and foremost, you know. And if anything, we would have thought that she would rely on the internal team to advise as to what is happening. But she ran with the matter herself.
Now, did you protest, you or the legal department?
Protest we did, Chairperson, but we didn't protest to her because we didn't have access to her. We went to the acting group CEO at the time, Mr. Lindikayazide, and we said to him, what is this that is happening as far as this matter is concerned? That the chairperson is now engaging the other side, and as the legal function, we are excluded from the matter. We even said to Mr. Zide, we said, but you know how it works within the organization. Why is it that you are not advising the chairperson accordingly? And his response was simply, you know, the chairperson is doing what he wants, she wants, and wanting to approach this matter in this way. So we left it, and I think we got to a point within PRASA where we understood that in this case we were a nuisance, and therefore we needed to be sidelined.
Now, there are a few developments, and we can either go into them or, Mr. Chairperson, the submission I make is they just deal with the same matter. It simply is a continuation of that process, which leads to what I want to raise with the witness. I don't know if you want me to deal with Annexure MN6 and MN7. My submission is they're not required.
No, just go ahead as you see it.
Yes.
I think it's fine, yeah.
Now, in regard to the communication with your department and the board, or the chairperson of the board, what was the nature of the communication in relation to the CIA matter?
We advised the chairperson about the matters and how we believed that PRASA had, you know, high prospects of succeeding in the matters. And we basically told her what Diale Mokhashwa had also indicated. And it was basically to say, well, we don't believe that these matters should be settled because we can win them. And that was in a nutshell, effectively, what our report was saying. And also, she had wanted to know who we had advised and so on. So we gave her that feedback.
Now, the next development is that you find out that you've been excluded. When I say you, the legal department has been excluded from the litigation process.
That's correct, Chair.
How did that come about?
Well, you know, I think, Chair, when you were in that environment, we knew one way or another as the legal department that matters would eventually come to us. So when the settlement agreement was going to be made an order of court, we knew that the papers would have to be served on us as the legal function.
I'm sorry to interrupt you. Let's go back a little bit. There was a time when you felt the need to go to the acting group CEO, Mr. Zide,
That's correct, Chair.
and you raised your concerns with regard to the role that was being played by the then chairperson, Ms. Mukubela.
That's correct, Chair.
Now, do you recall more or less when that was, when you went to raise this issue with the acting group CEO, or are you not able to remember?
It was around, November. It was at the time that
Yes.
the chairperson was making inquiries,
Yes.
into this matter. And because there were a number of meetings that were held, in fact,
Yes.
Diale Mohashwa,
Yes.
we bumped into him in the corridors of PRASA, and we would ask me, what are you doing here?
Yes.
And it would be the number of meetings that he was holding with the chairperson.
Yes.
So it was around that time, Chair, November, December.
As I recall what's in the documentation, the chairperson had just been appointed, isn't it,
That's correct, Chair.
at that time?
She was appointed, I think, in October.
Yes.
Yeah, so this was the first matter that she dealt with.
Okay. At the time you went to speak to the acting group CEO, had you come to the conclusion that the legal department, was being excluded from any dealings with this matter, or not yet?
No, Chair.
Not
Everything
yet.
was fine before the intervention of the chairperson.
Everything was still fine?
Yes, the
Okay,
legal
okay.
department was left to run with the matters and to report accordingly.
Yes.
Yes.
Okay, then continue and tell me at what stage you felt that the legal department was being excluded.
At the time,
Or did you speak at cross purposes?
no, we didn't.
Okay, let me ask again. Oh, Mr. Soni?
May I, because there
Yeah.
is an issue that does arise relating to that issue.
Yes, okay,
Chair.
all right.
Not a question of your feeling. What happened on the 15th of December, if you look at paragraph 40 of your affidavit?
On the 15th, Chair, Mr. Dingiswayo phoned. I was with Mr. Dingiswayo because we were concerned about the dealings of Diale Mahashwa with the chairperson and them not coming to talk to us, because the least we expected was that even after they engaged with the chairperson, they would say, look, this is where we are with this matter, this is what we've discussed with the chairperson. And when we realized that that was not happening, we then suggested to call, this is Mr. Dingiswayo and myself, to call Mr. Mahashwa. And he frankly said to us, look, I've been barred from speaking to the legal department by the chairperson of the board. And we left it at that, because we didn't want to put him in trouble.
Yes.
So we just said, okay, and we left it.
Okay.
But wasn't that, really, from your point of view, how would PRASA benefit if the legal department would be excluded in this fashion?
It just complicates things, Chairperson. I think as an internal legal function, we have a role to play as well. And, in terms of briefing attorneys as well, we understand the business and we would know what is happening better than the attorneys themselves. So, it was obviously unadvisable that we would be left out and our attorneys proceed with the matters. In fact, they took instructions from us, for them to be able to deal with the matters on behalf of PRASA as a legal function. And we obviously having, being in the field, we understood what issues were important and what not. So when that didn't happen, it was a concern for us.
Then on the 15th of December, a letter was written to Mr. Makashwa. What was that letter about? If you look at paragraph 42 of your affidavit.
Yeah. This letter, Chairperson, effectively was a letter advising Mr. Mahashwa about the settlement, agreement that would have to be made in relation to each case of of CIA. So the chairperson...
Do we have this letter somewhere? Because if it is there, let's go to it.
We don't have it.
It isn't in the documents.
It is not in the document. Is there no access to it so that we have a complete picture?
I can find the letter.
You can find a
Yes.
copy?
Yes, I can find the letter and make it available.
Yeah, okay. Okay, but tell me what the letter was saying and who it was from, who it was to.
The chairperson, Mr. Zide, was advised. Obviously, Mr. Zide was the acting CEO at the time, and he had been very close to the chairperson. So Mr. Zide was advising Diale Mohashwa, our attorneys, on the instructions of the chairperson, how the chairperson would have wanted these matters to be settled in respect of each case. So, and basically speaks to Ms. Makubela's instructions, where she then, lists the respective cases and the amounts that the cases need to be settled for. So she deals with all those in that letter. Yeah.
Are those details in paragraph 42?
That's correct, Chair. So you can see there, Chairperson, at the top of page 21, she says the matter was to be settled for the amount
That is page 297 at the top, yeah.
Yeah. The matter, is to be claimed settled for an amount of 7 million, the other one. So these were the instructions that were coming from the chairperson in relation to all those matters that CIA had sued us for.
Yes, do you want to just read that into the record, those amounts, how they were to be settled and the case numbers?
Yes.
Well, it starts the previous work.
So,
the letter goes on to confirm, I think, start from there and read up to the end of the paragraph.
The letter goes on to confirm Ms. Makubela's instructions as follows. Case 74281/2015 was to be pended until further instructions. In respect of case DB2, the matter was to be settled for the amount claimed, namely 7,098,481,066. Case DB1, the matter was to be settled for the amount claimed, namely 8,095,950,000. Case DB3, the matter was to be settled for the amount claimed, 371,739,087. The CIA rail case, the amount claimed was 21 million, but it was to be settled at 19,583,778,042. In respect of interest, this should be reckoned from the date of the summons. The letter concluded as follows. DM attorneys were to make the following offers to pay the liquidators of CIA DB 30,566,171.53 plus interest, and to pay the attorneys representing CIA Rail 19,583,788.42 plus interest.
Now, what we have read there, according to your affidavit, was how Ms. Makubele had said, according to the letter, the various claims by CIA against PASA should be settled.
That's correct, Chair.
But am I right to say that those that she said should be settled, actually, it wasn't a matter of them being settled. It was a matter of the instructions being to pay whatever amount was claimed. That seems to be what it says. Is that correct?
That's correct, Chair.
It was not a compromise or a settlement agreement.
No.
It was
Pay
the amount demanded.
That's correct, Chair.
In respect of all those where she said settle the amount as claimed.
That's correct, Chair.
And then And then the last sentence of paragraph 42 of your affidavit says, the letter concluded as follows: GM attorneys were to make the following offers. That is now PRASA's attorneys were being instructed
That's right.
to offer to pay the liquidators of CIA 30,566,171.53 plus interest. Do you know whether that amount, where that amount came from?
I think it was part of their
Was it, maybe let's start with this. What was the total of the amounts, the total amount that she was saying PRASA's lawyers should agree to pay in regard of all the claims mentioned there?
It was just over 56 million rands.
Just over for 56 million rand.
That's correct.
Okay. And then there is that amount of 30,566,171.53 cents. In respect of what was that? Do you know?
Yeah,
Because your paragraph here doesn't say what that was for.
I guess it's the amount that was claimed by CIA. So she wanted us to pay the liquidators that amount of money to settle
Yes.
that.
But when all these claims were the claimant was CIA, isn't it?
That's correct, Chair.
So why would some amount be paid to the liquidators and not the whole amount?
Well, Chair, this was what was confusing,
Yes.
with this whole matter, because
Because if a company is under liquidation, then whatever the company was owed
it goes to the
must be
liquidator.
paid to the liquidators.
That's correct, Chair.
Yes.
Yeah.
Is this one of the things that puzzled you?
It did. It
Yes.
did, Chair, because, Chair, liquidation, we understand that the liquidator is the one that takes over.
Yes.
And you deal with the liquidator and not the party
Yes.
itself. But in this particular case, that was not the case.
Yes. Now, so this 30 million rand in the last sentence of your paragraph, you say was part of the 56 million or so?
Yes,
Yes.
yes,
So the total amount was just over 56 million.
that's correct, Chair.
And out of that 56 million plus, she was saying 30 million
Must be paid to
which
the,
must be paid to the liquidators.
that's correct, Chair.
And then to pay the attorneys, they're representing CIA. Well, one would have thought that such attorneys as they would have been to pursue these claims would be attorneys of the liquidators.
That's correct.
And not CIA.
That's correct.
Yes. So do you know whether, as at this time, there were attorneys instructed by the liquidators, and then there were attorneys who had previously been instructed by CIA, or was it the same attorneys?
It was not the same attorneys, Chair.
It was not the same
No,
attorneys.
it was not the same attorneys. The liquidator had its own attorneys,
Yeah.
and CIA had its own. But in this case, we were not dealing with the liquidators' attorneys. We were dealing with CIA's attorneys. The issues around liquidation were basically, put aside in terms of
Yes.
having to comply with the manner in which you would run this type of case where a liquidator is involved.
Yes.
So she called the attorneys of CIA
Yes.
and started talking to them.
Do you remember whether at the time that she and her board were appointed, the liquidators' attorneys were in correspondence with PRASA or PRASA's attorneys?
They were, Chair.
They were.
So the liquidators would speak to Diala Mahasha.
Yes.
Yes.
Do you know whether prior to her appointment and the appointment of her board, the so-called CIA's attorneys were continuing to be in correspondence with PRASA?
Yes, Chair. In terms of the arbitration proceedings,
Yes.
yes, we would
In respect
communicate.
of that.
That's it, Chair.
Yes. But why was that? Why was that necessary once CIA was in liquidation? Because I would have imagined, even with regard to that should have been under the liquidator's control.
They would have, Chair, in terms of the companies, the CIS group had a number of companies. So CIA Engineering, Consulting Engineering, is what they had put under liquidation.
Yes.
And the others remained as part of that group.
So the arbitration related to other
The other
entities.
as part of the S group, yes.
Yeah, not
And that
the
they had
one
placed-
under liquidation.
That's correct, Chairperson.
So is it possible, therefore, that some of these amounts that she was giving instructions on did not relate to the entity that was under liquidation?
But to the ones that were in arbitration with us. That's correct, Chair.
That's correct.
Yes.
So in that case, then, except for the fact that she, being chairperson of the board, was getting involved in these matters, there would be no problem with dealing with CIA's attorneys insofar as they represented entities that were not under liquidation.
That's correct, Chair.
Yes. So do you know whether the amount that she said should be paid to CIA's liquidators, whether that would have related to the only claim or claims that related to the entity that was under liquidation?
It would have been to the claim that related to the company that was in liquidation.
Yes. Okay. So insofar as she talks about amounts that related to entities that were not under liquidation, somebody at PRASA would have been entitled to deal with those attorneys.
That's correct, Chair.
Insofar as she talks about amounts that related to the entity that was under liquidation, somebody at PRASA would have been entitled to speak to the liquidator's attorneys.
That's correct, Chair.
Okay.
Chairperson, if I could be helpful, in regard to the figure of 30,566,171.53, you'll see, Mr. Chairperson, that is the sum total of the first three amounts reflected on page 297.
Okay.
So you add 7 million, 8 million, and 15 million, you'll get the 30.56 exactly.
Okay.
And then, of course, the 19 is the one that is the fourth figure. So that's how it's divided into two.
Okay. No, thank you.
Now, the chairperson gives instructions on how the matters are to be settled. But what happens next, and you deal with that at paragraph 43 of your affidavit, Ms. Ngoi?
In paragraph 43, I talk about a letter that CIA's attorneys wrote to our attorneys.
Yes.
Right. In fact, in that letter, Chairperson, CIA's attorneys complained about the proposal that was made by our attorneys, reflecting effectively that that's not what they understood to be the instruction coming from the chairperson.
Okay, I'm sorry. I was going to ask you to start afresh on that.
No problem, Chair. This a letter that CIA's attorneys wrote to our attorneys, right? They complained in that letter about the fact that what our attorneys had represented as offers of settlement was not a true reflection of what they understood to be the case.
Okay, now we skipped something. Did GM attorneys carry out these instructions as per the instructions given in that letter?
Yes, Chair, they did.
They did, in accordance with the amounts given there.
That's correct, Chair.
Okay, and then what happened?
So
CIA's attorneys came back
and complained that no, these amounts that you are reflecting as settlement amounts are not what we understood to be the offer coming from PRASA.
Yes. And have we got that letter here?
We don't, Mr.
We'll provide the letter, Chair.
Yeah, okay. It should be provided. Yes. And what happened then?
Sorry, Mr. Chairperson, may
Yes.
I just... In fact, they don't say it's in terms of the offer. If you read what they say, and you've put that in inverted commas,
Yes. The attorneys complained that the tender made did not
I'm
correspond.
sorry, where are you reading from?
Paragraph 43, Chair.
Paragraph 43.
Yes, on page 297.
Okay.
It says, after the tender was made, CIA attorneys complained that the tender made did not correspond with process-specific and express instructions.
And
you have quoted specific and express instruction that was in their letter.
Yes.
Okay,
Yes,
which
Chair.
you saw.
Yes, Chair.
Yes. Okay.
And what is your comment about that, the fact that they knew what the specific and express instruction was?
It looked odd, Chairperson, that the attorneys of the other side would have been advised, by somebody in PRASA of what the specific instructions were. We found that improper, in fact, to say, how is it that they seem to know? Our lawyers, in any event, had written what they thought they understood to be the case. But in this regard, CIA's attorneys come back and say, no, those were not the express instructions. So in our mind, it was very clear that they were communicating, with the chairperson around these matters. And that's why they could boldly say, it's not what was offered. Yeah.
All right. As a consequence then, forgetting all of these concerns that you raise, I'm not saying they're not important, but just to take the process forward, what happened next insofar as having the matter settled at the arbitration proceedings?
The offer, our attorneys then revised the offers to accord with what CIA's attorneys had communicated to them. And that is what was then sent to the arbitrators to be made.
We are skipping.
Okay.
Okay. It seems natural that the attorneys for CIA would have been asked by your attorneys, where are you getting this from? Didn't they ask that?
I don't know, Chair. One would have expected that, but as to whether it happened, I can't comment.
Well, I would have expected you to ask DM. I know that they had said that they were barred from talking to you, so maybe that's the reason why.
Yeah, we stayed away, Chair.
Yes. But internally, within PRASA, did anybody ask who knows anything about what these attorneys are talking about? Did anybody ask?
Well, we knew that Mr. Zide, who was close to the process, would know what was involved. So, and
but you left it.
No, we left it at that.
You had no role.
Yeah, no.
Yes. Okay. And you have now talked about PRASA's attorneys sending a revised offer. But you are skipping. Somebody within PRASA must have given them instructions for a revised offer.
Yeah.
How did that come about?
They were speaking to Mr. Lindikaya Zide at the time, who was the acting
Group CEO.
Group CEO.
Yes.
There was a point where Mr. Zide became the the company secretary. His official position in the organization was company secretary.
Yes.
But at this time, when these negotiations started, he was the
acting CEO.
That's right. And then was later removed. I think he was removed around about December. But he was the one that had engaged quite extensively in the meetings that the chairperson had with our attorneys, Diala Mahashwa. So he would have known, and he would be the one that we understood that he was the one that then communicated to our attorneys to say, fix the offer.
Do you know whether he would have been part of whatever meetings the chairperson may have had with whoever in regard to these matters?
Yes, he was, Chair. We took issue with him.
Yes.
To say, how we work. Why are you not advising accordingly? So he did. He was basically, even when he became company secretary, I suppose, from a board relationship, he continued to be part of those meetings.
Okay, all right. So he instructed PRASA's attorneys to send a revised offer.
To revise the offer.
Are you able to indicate how the revised offer looked like, or not really?
Well, I guess, Chairperson, the revised offer would be in accordance with the letter that Advocate Makubela.
I'm just wondering what room there was to revise the offers when the amounts that the process attorneys had been instructed to offer were the amounts claimed.
Yeah, I think it was around the interest, when interest will be calculated, Chair, because you'll recall in the letter that the Chairperson writes,
It was said from the date of summons.
That's correct, Chairperson.
Yes.
Yeah.
So they wanted it earlier than that.
Exactly.
And then the instructions were given to say they must make it earlier than that.
That's it.
Oh. And do you know whether, by chance, in the summonses they had claimed interest from a date earlier than the summonses?
No, Chair.
It would have been from the date of the summons.
That's correct, Chair.
Yeah. And is that something that you are sure about because you had a look on?
Yes, I'm sure, Chairperson. Yes.
So to the extent that they may have wanted interest to
from the beginning
to run from dates earlier than the dates of summons, they were claiming something that they were not entitled to.
That's
in
correct,
terms of
Chair.
the litigation.
Which is something we would have opposed.
Which you would have opposed.
That's correct, Chair.
Yeah. Okay.
Now, the revised offer is made, and was that revised offer accepted?
That's correct, Chair. It was accepted.
And pursuant to that settlement, in respect of the arbitration, how was that brought to, or purportedly brought to an end?
Well, in terms of, on the 7th of February, Advocate Waters and Mr. Mahashwa approached.
Don't take away from the...
Sorry,
yeah.
Chair.
Look at me.
I forgot for a minute there, Chair. The attorneys for CIA, as well as our attorneys, then approached Judge Brandt, who was dealing with the arbitration process, requesting...
he was the arbitrator.
Yes.
Yeah.
And to make the terms of the agreement, to award a settlement agreement.
Was there a written settlement agreement that had been concluded?
That's correct, Chair.
Yeah,
there
so
was.
the parties agreed that the settlement agreement should be made an arbitration award by
That's
consent.
correct. That's correct, Chair.
Okay.
Now, just for the record, Ms. Ngowi, when we're talking about Judge Brandt, we are talking about the retired judge of the Supreme Court of Appeal.
That's correct, Chair.
Sitting with the hat of arbitrator.
That's correct, Chair.
Was he the only arbitrator, or there were 2 or 3 arbitrators?
In the CIA matter, he was the arbitrator, Chair.
Yeah.
It's in the Siangena matter where we had 2 judges.
Yes. Okay.
Yes.
Then, what is the next incident, or what is the next development following the order being made, an award being made in terms of the settlement agreement?
Chairperson, the CIA's attorneys then brought an application to have that award made an order of court so that, it would be easy to pay once it's a court order.
And when was that?
It was in March 2018, Chairperson. We actually didn't know as the legal function that this was happening. In fact, somebody from outside advised us of that fact, and we were able to then, intercept that process of making the order.
Making the settlement,
an order of court.
Actually, it was to make the award an order of court, because it was now an award.
Yes, it was an award now, Chair. Yes.
Now, Ms. Makubela, you knew that the award had been made in terms of what Ms. Makubela had said a process should settle for. That now is an attempt is made to make that into an order of court. On what basis could you, what authority would you have to oppose that application to make the award an order of court?
Chairperson, as the head of the legal function, and also in terms of the delegations of authority that have been given to me by the board, in terms of these type of matters, I knew also in terms of the delegations of authority who has authority to do what. And in relation to this settlement, which was negotiated by the chairperson, for me it was clear that the chairperson did not have authority to be negotiating settlements with parties, also to the exclusion of the legal function. In fact, the delegations of authority do not provide for that. So, and also knowing very well that there is no ways that PRASA could have settled these matters because we knew our prospects of success was quite high. And also taking into consideration the fact that, our attorneys told us that you are barred from being part of this thing. So, you put all those issues together and you realize that, clearly this thing was not done properly. It was outside of the authorities and we could not, as the legal function, allow it to proceed. So we then, engaged another set of attorneys to the exclusion of Diale Mokhashwa to say, go defend this matter for us and oppose it.
You said this was around what time and which
This
year?
was 2018.
2018 when?
March. March, yes.
Was Ms. Makubela still the chairperson?
Yes, she was.
Okay, but
Yes.
you decided to intervene nevertheless?
Yes, I did. Chair.
Yes, okay, continue.
Stevenson, just for you, I want to ask Ms. Ngoi to look at something. On page 298, in that unnumbered paragraph, on the second line is a date, and that date is the 9th of May 2018. What is the correct date?
No, the settlements were made in March, Chairperson. This was the date for the hearing of the award being made an order of court.
Well, it looks like
The application was set down for the 9th of May.
it looks like you may have skipped something important in the preceding paragraph. 45 on page 298. You said you instructed a different firm of attorneys. You didn't tell me which firm and so on.
The firm of attorneys we instructed was Bowman Gilfillan, Chairperson.
Oh, sorry.
Yes, continue, Mr. Soni.
And the reason you appointed a different firm of attorneys was that related to the fact that DM attorneys had played a role in having the agreement made an award.
Yes, Chair. We found that Diale Mokhashwa was conflicted in this regard. And we decided we are not going to continue with them because they were party to the process. And so we went with a different law firm and we chose Bowman Gilfillan to oppose the application.
So you say, because this date is going to be important in Singoi, I'm going to ask you now to look at paragraph 46. And you say there at the hearing on the 9th of March. But you then say earlier in the second line on that page, it was set down for the 9th of May. Surely both those can't be right.
No, that's correct, Chair. There must be a typo. I think it's...
So what is the correct date?
Let me just go back. The matter was set down in May, so it would be the 9th of May.
No, it was set down for March.
Let me just remember, Chairperson. This matters happened a while
Okay.
ago. In March 20, we became aware that CIA had brought an application. So that's when we became aware.
In March?
In March 2018.
Yes.
Right? Of
Yeah,
an
you
application.
do say in paragraph 45, it was set down for 9 May.
Yes.
Yeah,
It was set down for
second
9
sentence. Second sentence on page 298.
May. That's correct, Chair.
Yes. But there's something that is important that I want you to deal with about the power of attorney and CIS attorneys challenging Bowman Gilfillan's authority. Tell me about that.
Chairperson,
After you had instructed Bowman, Gilfillan, what happened?
we were advised, in fact, by the attorneys on the other side, that the chairperson had written to them, advising them that we did not have authority to appoint lawyers, and therefore Bowman Gilfillan was not authorized, to act on behalf of PRASA. In terms of the delegations of authority, Chairperson, the authority to appoint attorneys is given to the head of the legal function, which is myself. And so when a Rule 7 notice was issued requesting authority, I then prepared the power of attorney to Bowman's, reflecting that they were authorized to act, and we also attached the delegations of authority to show that, I was able to do that. But the chairperson had advised the opposition that we didn't have authority to act, and we therefore also didn't have authority to appoint Bowman Gilfillan.
Now, you say you got to hear this from Siyaya's attorneys, is that right?
No, the issue of, yes, in terms
the
of
challenge.
That's it,
The
yes.
challenge to Bowman Gilfillan's
Yes.
authority.
Yes, Chair.
And your authority to appoint them.
That's correct, Chair.
Now, was that in a letter that Siyaya's attorneys sent to Bowman?
It was a telephone message.
A message?
Yeah,
Was
it was
it
a
sent
message.
to you?
Yes, we saw the message. Their attorneys, in fact, sent
atten-
us an excerpt
Yeah.
of that communication they had with the
That is
chairperson.
now the attorney from Bowman's.
The attorneys from Bowman's were given this excerpt
Yes.
by the attorneys of Siyaya, so they sent it to us to
Yes,
say, look, this
yes,
is what has
yes,
been said.
yes. And what did the text message actually say? Just repeat that. Did it say that Bowman's had no authority to represent PRASA?
Yes, something to that effect, Chair. I can't paraphrase it properly, but
Yes,
effectively
but
it said.
effectively that,
it
yeah,
said
no,
that.
that's fine.
Yes.
Yes, and what did you do after learning about this challenge?
No, we said to Bowman's they must continue.
Yes.
They must continue to go to court because we didn't agree
Yes.
with what the chairperson had informed them.
Yes.
And we thought, based on, the documentation that we had given in support of the authority and the power to act, that it would be sufficient to the court to show that, no, we do have the necessary authority.
And did you report this to anybody else, or this whole issue?
Yes, we did, Chairperson.
Who did you report?
In fact, when all this was happening, we wrote to the board. Mr. Dingiswayo wrote to the board to say, are you aware of this? And has the board authorized the chairperson to be conducting and concluding settlement agreements? But we got no response from the board, And what we also did,
Before that, when you say you wrote to the board, did you write to every member of the board?
every member of the board,
And not a single one of
not
them
a single one,
responded?
not a single one responded, Chairperson.
Not a single one of them called you in response to that letter?
Not a single one, Chairperson.
They said nothing?
They said nothing.
Okay.
Yeah.
And who else, if there is anybody else you reported this to?
At the same time, Chairperson, so when one letter was going to the board, I wrote a letter to the minister as well.
And who was the minister at the time?
Minister Bladen Zamande.
Yes.
At the time,
He was Minister of Transport.
That's it. He had just come into office. So I wrote to the minister explaining to the minister that we are settled with this issue and we need intervention. We also wrote to the portfolio committee of transport to say, look, help us. We've got this situation within PRASA and we don't know where to go. So those letters were sent to the various people that we thought we could escalate the matter to.
Did you find any joy with both parties, namely the minister and the portfolio committee?
Well, the minister came back to us, Chairperson. In fact, the minister really came forward and called a meeting. But perhaps I may say, Chairperson, when we were in court, the court, the judge, upheld the fact that we didn't have authority to act, so granted a default judgment against us. So we were also saying to the ministers, give us authority to apply for rescission of this matter, because the chairperson was still there, and she was not actually interested in us applying for rescission. So we needed some form of authority. So when we raised that with Minister Blade in Zimande, he called a meeting immediately after he had received the letter to engage both parties. And we had...
Both parties being?
Being the chairperson of the board. In fact, it was the chairperson of the board and the legal function of PRASA, together with the acting CEO at the time, Mr. Kramet Molepo. And the company secretary was there as well. So the minister wanted us to, obviously speak to him about this matter and advise what had transpired, because clearly you had conflicting views from the same entity around a matter that required PRASA to pay monies to a supplier.
Well, you may as well, for the completeness, tell us the meeting took place.
Well, the meeting took place, Chairperson, and it was very clear in the meeting that the chairperson was offended.
Offended by what?
By the minister, having asked her to come to a meeting with managers of PRASA without the minister having engaged with her first, because that was the first encounter that the chairperson had. And in that meeting, Chairperson, the minister then, after hearing both sides, from the chairperson and from myself, the chairperson felt that she didn't want to go into the merits of the matter. She was not there for that, and she didn't want me to go into the merits of the matter as well, and she would rather have reports drafted. So the minister then requested...
She would rather have what?
Reports.
A report?
A report drafted for the minister.
Okay.
Yes. So the minister then said, okay, I then will need a report that comes from PRASA on this. And I said to the minister, with the greatest respect, I don't think I can do a report with the chairperson. I rather suggest that the chairperson does her own report, and we as the legal function do our own report. And the main issue for us is for you also to give us authority to apply for rescission of the matter. And we left the meeting on the basis that each party, given a specific date, would then go and prepare the reports. So we, as the legal function, myself and Mr. Dingiswaya, put a report together for the minister, and we submitted the report. The chairperson did not produce a report at all. In fact, and we then got a letter from the minister, an instruction from the minister to say, defend PRASA's interests accordingly in this. And that's when we rushed to go and interdict the sheriff from paying the monies that the sheriff had already attached. So effectively, immediately after the summary judgment was given, the sheriff went and attached our bank account and would only release the monies within 30 days of that. So we were hoping that we would receive instructions from the minister, and we did. And so we were able to then challenge the release of the monies by the sheriff.
Yeah.
And we were successful in that respect.
I'm sorry, Mr. Sonny.
No.
I needed to just hear the whole part.
Absolutely.
Okay, you may continue.
I just want to place, so that when you look at the documents, Chairperson, just place on record that if you look at page 298, that's the unnumbered paragraph of your affidavit, you'll see there that there is a reference to Annexure MN8. Is that your letter to the minister in which you ask for the meeting and ask him to intervene?
That's correct, Chairperson.
And you've already indicated he did intervene.
That's correct, Chairperson.
In your letter, you then say to him, and your letter is dated the 16th of March, you say to him that the application brought by CIA was granted and the arbitration award was made in order of court.
So you're referring to the date of March, Chairperson. So I may be getting my dates mixed up, Chair. I must concede.
Yes. Well, if the letter is here, let's go to it.
Yes.
Yeah, what page is it?
Is that page 263, Chairperson?
263.
364.
364.
363, sorry.
Yes.
Yes, it was not.
I see the letter is written by two people, yourself and Mr. Dingiswayo,
That's correct, Chair.
and is addressed to the Minister of Transport, Dr. Bongosi Inzimande. Yes.
That's March.
Continue.
In essence, what do you say to the Minister in this letter?
We basically complained to the Minister of Transport, stating the fact that the chairperson of the board, exceeded her authority effectively in settling these matters, and that the rescission, we would request the Minister to approve that we apply for the rescission of the judgment that was taken against us.
I'd like you to look at paragraph 2. Sorry, Ms. Nguri. Just read that into the record, please.
The chairperson of the interim board is correct to say that the matter in question is by all accounts a small matter in the context of PRASA.
Now, we've dealt with the amounts, and we know whatever it is in the region of 50 to 60 million rand.
Yes.
And would you regard it as a small matter?
Well, in the bigger scheme of things, Chairperson, I guess 56 million rands when we deal with billions at PRASA was a very small amount, and I think what concerned one was
That's a lot of money to the taxpayer.
It is a lot of money to the taxpayer, Chairperson. In terms of, dealing with matters that would concern the Chairperson, obviously from a focus perspective, this is what one was referring to. Because if you look at the delegation of the group CEO at the time, his delegation was 100 million. So 58 million really would not be something that the board would really settle themselves with.
Would need to go to the board.
That's it,
yes.
That's it. So that's the context within which we saw that indeed, it is a small amount of money where things are concerned within PRASA, and therefore we didn't understand why she had placed so much emphasis and importance of the matter.
But isn't that really the issue? That on the one hand, she says it's a small amount, and that's what is reflected in the letter. But on the other hand, she spends so much of time getting information from people, giving these instructions, revising the instructions. And why would a chairperson of a board do that?
Well, it was a question that we had as well. And it was suspicious at the end of the day, to say, how is it that so much time by the chairperson of the board, and it is the first port of call, really, where the chairperson was concerned, to then deal with this matter and to deal with it in the manner that she had dealt with it, and for herself to concede that it was a small amount. We agreed that you then don't concern yourselves with matters of this nature, and in any event, as the chairperson, you don't have authority to settle agreements on behalf of PRASA. And that comes from the delegations of authority that is prepared by the board itself.
Did you ever get to know, and maybe Mr. Soni was still going to ask you about this, whether the board had authorized that these claims be settled, and I put settled in quotation marks, in the manner that she had said the attorneys for PRASA should be instructed to settle them?
No, Chair. We actually inquired.
Yes.
And as I said, there was no response from the board.
Yes.
And one of the board members, Mr. Olila George, we engaged him because he was a long-standing member of the board. And we went to him, we said, but what is happening? Have you, as the board, given authority to the chairperson to deal with this matter? And he said no. So we knew, Chairperson, that this was something that the chairperson was running herself.
And as you sit there, you know that definitely there were no such resolutions.
There was none, Chairperson.
Yes.
And it was not even mentioned, according to the person you spoke to, it was not even mentioned at the board meeting.
No, Chair. No. I mean, the letter that the chairperson writes was to brief the board. But as to whether, it happened is another question. But what we knew, because that was one of the issues that we had requested from Mr. Zide as the company secretary at that time, to say, give us the resolution of the board that authorizes the chairperson to enter into the settlement agreement, having regard to the delegations of authority.
And what had Mr. Zide's response been?
He said there wasn't any.
Did you ever, you said earlier on that Mr. Zide was close to the chairperson, is that right?
That's correct, Chair.
And I think you suggested that he also would have been with the chairperson in whatever meetings the chairperson may have had with various parties relating to these claims.
That's correct, Chair.
Yeah. Did you ever ask him, why are you getting involved in these matters in this way when you know it's not right?
We did, Chair.
And what was his
We
answer?
asked him. And his response really was along the lines that, but the chairperson wants to deal with these matters in this way. We really took serious issue with Mr. Zide, chairperson. He was a colleague.
Yes.
We had worked with him, and we had a particular way of working. And we told him, we said to him, it's interesting that you spend so much time with the chairperson and you are busy instructing lawyers on the instructions of the chairperson. You're not even coming to us. We're in the same corridor with you. Why are you not speaking to us? So we took issue with Mr. Zide on this thing, and we said to him, we are not happy. And we are noting what is happening within the organization as far as these issues are concerned. Mr. Zide was before me a legal advisor for PRASA before he became the company secretary. So he's a lawyer, he understands the issues as well. And we really did tell him that we're not happy with how he as well was conducting himself where the chairperson was concerned.
As you sit there, are you quite clear in your own mind that Mr. Zide knew that what was happening was wrong?
I'm sure.
And he continued to participate in
Yes, Chair. Sure, he knew.
Okay.
As you please, Chairperson. Now, can I just ask, the issue of, the matter comes in court. What happens in court in relation to the point taken about PRASA's lack of authority?
Well, when we went to court to oppose the application that they had made, the judge obviously, recognized the fact that the instruction coming from the chairperson of the board weighs more than just what the power of attorney was saying. And therefore, he decided the matter in favor of Siaya and against PRASA. And we were obviously, settled with having to now apply for the rescission and taking the matter forward, Chairperson.
But Ms. Ngoyi, isn't there a problem with the way the matter was dealt with? Whoever fault it is, doesn't matter. On your version, and I'm not saying it's wrong, the chairperson had no authority to conclude the agreement or to agree to the agreement.
That's correct, Chair.
Secondly, the chairperson had no authority to contract lawyers on behalf of PRASA. That was your function. That's in terms of the delegation.
That's correct, Chair.
Was that pointed out to the judge?
Well, I guess, Chair, our attorneys, found themselves on the back foot. Remember, we came to hear about this matter just before it was going to court. So we needed to act speedily and brief the lawyers speedily. So we hadn't had enough time, I guess, to talk to our attorneys properly around the issues of authority and so on, because naturally, with the Rule 7 notice, once the power of attorney has been granted, it suffices, and that's what we thought would help us deal with the matter as far as authority was concerned. But that note coming from the chairperson weighed against PRASA, and I guess the judge looked at it on the basis that she is the chairperson of PRASA, and therefore it must be that these people do not have authority.
It was an acting judge, though.
That's correct, Chair.
The arbitration award is then made an order of court.
That's correct, Chair.
What happened from CIA's point of view once it had got an order of court?
Chairperson, the sheriff was then instructed by CIA, in fact, immediately to go and attach one of the bank accounts of PRASA. If I recall, I think it was our ABSA bank account that was attached. And obviously, with a court order, you know, the sheriff could do so.
Now, in the meantime, all of this is happening. You are acting in the best interests of PRASA, given the delegations and so on. The chairperson has obviously communicated to the other side even that you don't have, or purportedly don't have, authority. Was there any communication between you and the chairperson in relation to how this matter on the 9th of March was dealt with in court?
No, Chair, there wasn't. In fact, I think the relationship was strained at that time. In fact, what I then understood from the group CEO at the time was that we, as the legal function, were not authorized to go and defend that matter. In fact, that was the instruction that I received from the group CEO. And I was very clear, you know, I said to the group CEO, look, Mr. Kramet Molepo at the time, at EXCO, I said, I don't take unlawful instructions, not from anybody. And I am going to defend this money of PRASA because we do not owe CIA this amount of money. And it was during that day, Chairperson, that all these communications were happening, you know, between the chairperson and the other side. And I raised that with members of EXCO. I even said to the executives that were responsible for the contracts on which CIA had sued us to say, are you aware that this is happening? Are you aware that the contracts are now being settled? So they themselves didn't know that there was a settlement a process that was happening. So, you know, the relationship between me and the judge was strained. I mean, and the chairperson was strained at the time. And in fact, what the chairperson had then said is that I should be disciplined. I should be disciplined.
You should be disciplined.
That's correct.
For what?
For having acted without her consent in terms of briefing the attorneys, and also the fact that I knew that she was saddled with dealing with this matter.
But she didn't say this to you. She said it to somebody else, and you heard from somebody else.
This was to the group CEO,
yes,
who then advised me.
Yes.
Yes, that the chairperson wants me to you know.
To be disciplined.
Yes, Chair.
Yes. What was your reaction to this news?
I was fine, Chair. I said fine.
Yes.
I mean, we'll have to deal with the disciplinary action as and when it comes.
Yeah.
I even said to him, look, it's not the first time that I would be disciplined for doing the right thing within PRASA.
So you had, from what you have told me, you had been subjected to dismissals and suspensions, or a dismissal and a suspension during Mr. Montana's time. That was coming from the group CEO. Now there was a threat of disciplinary action emanating from the chairperson of the board.
That's correct, Chair.
Yes, against you.
Yes, Chair.
And on both occasions, well, certainly in regard to the first one, ultimately nothing was shown to have justified the suspension and dismissal as far as you are concerned.
Yes, Chair.
And in regard to this new threat, as far as you were concerned, you were just doing your job. And
I was just doing my job, Chair.
You were acting on the basis of a delegated authority that had been issued by the board and which had not been revoked.
That's correct, Chair.
Yes.
All we were doing was protecting PRASA.
And you were protecting
the interests of
PRASA's interests as far as you were concerned.
Chair.
And your point was either all or some of these claims from CIA that the chairperson had said should be paid were not owed
That's correct, Chair.
at all,
That's correct.
and that was your position.
That was correct.
Yes. Okay.
And of course, you were saying we can't settle this matter given what we know about the matter and what our lawyers have told us.
That's correct, Chair.
Now, the sheriff then attaches 59 million rand of process money, which the chairperson didn't think was a large sum of money. And I'm just saying it because I'm still surprised that 59 million rand in an organ of state is not regarded as a large sum of money. And I wonder what the Auditor General's view of that statement would be, but that's a different point. What happened next in the protection of process interests?
Chair, so the sheriff attaches, right? And we then had engaged the minister. That was the time that we had requested the minister to come to our aid. So we waited, for the minister to say, yes, please rescind the matter for PRASA. And also at the time that we got the go-ahead from the minister to say defend PRASA and defend the interest of PRASA, we had really run out of time. I think it was about a day or two before the sheriff was authorized to release the monies to the other side. So we had to rush and to bring the application on an urgency basis, to say we want this to not proceed. And obviously we knew that we were going to be challenged around issues of urgency, because it could be argued that the urgency is brought on by ourselves, and therefore the matter was not urgent. But, we were then able to really convince the court, based on the papers that we put forward, that there was something untoward with the manner in which the settlement agreement was awarded, and that we would want the sheriff to be interdicted from paying out the matter so that we can deal with the rescission of the matter following that process. So the idea was to get back the money for PRASA and make sure that it doesn't go, because we knew the minute it leaves the sheriff, we would never see it.
You effectively took two steps. The first was to secure an interdict restraining the sheriff from transferring the money to CIA.
That's correct, Chair.
And the next was to bring a rescission application.
That's correct, Chair.
Was the interdict application granted?
The interdict application was granted, Chair.
And the rescission application?
The rescission application was also granted in favor of PRASA.
And
at the time of the granting of the interdict the granting of the interdict, what kind of time in 2018 were we talking about? Around March, April?
Yes, it was
May.
around. It was around. I'm getting my dates wrong, mixed up,
Yes,
Chairperson.
but somewhere around March, April.
That's it. That's
Yes,
it.
and the rescission happened
It happened later.
much later.
Yes, because we
Okay.
dealt first with the
Yeah.
interdict.
Okay.
when did Ms. Makubela leave the board of PRASA?
I think it was around about June, Chairperson. Let me just get my facts. I know I
Wasn't it
stated.
the 17th or the 27th of March?
Let me just see. What I know, Chairperson,
I think it must have been around either March or April.
March,
I think
April.
I've seen something like that. That's by
No, it was
May and
after.
June, she was no longer there.
It was after March, Chairperson, because the 25th of April, we held a meeting with the Department of Transport. No,
You'll
no, I'm
find
looking-
it
I'm looking at
page 299, paragraph 51 of your affidavit.
Okay, sorry, I was looking at the wrong, yes. On the 23rd of March, the resignation from the board was announced on the 23rd of March,
But with effect
with
from when?
effect from the 16th of March, 2018.
With effect from,
The 16th of March, 2018.
was it kind of backdated?
That's correct, Chair.
That's interesting. Yes.
Chairperson, I see it's 4 o'clock. There's still a fair bit on this to be dealt with. I don't know whether you want me to.
I suspect there is still a lot to be dealt with by this witness, is that right?
Yes.
Because we haven't, she hasn't given evidence relating to the two other affidavits.
But this, fortunately, this affidavit is nearly done.
This one is nearly done. How long do you think it would take us to finish this one?
Chairperson, it raises a number of issues. For example, what Ms. Makubela's role is, not only in this, but how she got appointed and what should have happened in between. And I suspect it will take at least 45 minutes to an hour to deal with that as a whole, Chairperson.
Okay, and that would then be the end of this affidavit?
It would be the end of this affidavit.
And these other ones, the rest of her evidence might need how much time?
Chairperson, the next affidavit I deal with, which is the one that Ms. Ngoyi made yesterday, is really summarizing for you the main aspects in the Siangena matter. The papers are before you, and she just highlights.
Yes.
So that, I suspect, will be quite expeditious.
Yes.
And in the DBSA matter, we are going to cut it down to the finest details. We've already discussed that. So I don't think Ms. Ngoyi will be more than about 2.5 hours tomorrow.
Yes, okay. That is once we start with the other affidavits.
No, altogether.
Excluding finishing on this one.
Yes.
Excluding finishing on this one. Okay. I'm trying to see whether and then Mr. Dinguswayo, you said he's coming tomorrow.
Ms. Ngoyi has dealt with many of the matters.
Yeah.
So it will be to some extent confirmatory.
Yeah.
He will just deal in a little more detail with the prodigy matter.
Yeah.
Because he dealt with the contract itself.
Yes.
But that would be the main thrust of his affidavit.
Yeah.
He deals quite a bit with the CIA settlement or purported settlement. And so, in a sense, we can just get him to confirm it.
What's your estimate of how much time we might need for Mr. Dinguswayo?
I don't think more than 2.5 hours at maximum.
So we should be able to finish both of them tomorrow.
Yes.
And then you have Mr. Popomlefe and Ms. Kuyama.
That is so.
Mr. Popomlefe will be about, what, 2 hours?
About 2 hours, yes.
Then Ms. Kuyama would be your last witness for now, this session.
And then we've got Mr. Ahmed, Zaki Ahmed.
Oh, we have Mr. Ahmed.
But can I, in relation to Mr. Ahmed, Chairperson, it is to a large extent, his affidavit replicates to a large extent what he said to the portfolio committee. And so in that sense, it's not details of first-hand knowledge. It's the sort of thing one can say, well, we know you've said this, and what inferences can be drawn from.
It's already there.
Yes.
So there's no need to be long with him.
I do not think so.
I was wondering whether we should stop for the day now or whether we should take maybe like another 30 minutes or so and see if you can finish with her on this affidavit or whether we should just adjourn. What do you say?
Chairperson, I know the witnesses had a long day because a number of matters that she was not expecting to be probed. I'm just assessing from what I'm seeing of the witness. I don't know whether.
Ms. Moe, how do you feel about do you feel You can still go on if I say let's go on, or you feel exhausted now?
I can go on, Chair.
You can go on.
Yes.
Yeah. Maybe let's take a 5 minutes break.
Yes.
And then let's see whether you might be able to finish her evidence in relation to this affidavit. And then we proceed. Is that fine with you? I forgot to check with you. That's fine. Okay. Let's take a 5 minutes adjournment.
Yes.
We adjourn. Okay, let's proceed.
Now, in relation to the rescission application which was granted, what did you use as the basis on which you persuaded the court to rescind the order granted by the acting judge?
We obviously put the affidavit together, Chairperson, that spelled out the conduct during the process, and also, reflecting the issues around lack of authority of the chairperson to having concluded the settlement agreement on behalf of PRASA, and the manner in which the chairperson had also engaged, with the other side's attorneys to the detriment of PRASA, where, it should have not been. So those were some of the arguments that we put together, in our case.
I'm sorry. Prior to this stage, the stage where you applied for an interdict and you applied for the rescission of the judgment, and particularly as the events were unfolding at PRASA, and as far as you were concerned, the legal department was excluded from these CIR matters by the chairperson. Do you know whether the chairperson was aware that you were saying the delegated authority for instructing attorneys was with you and not with the chairperson of the board?
Chair, in fact, as far as that is concerned, where I was sitting, I would have expected the board, at least the board chairperson, to have familiarized herself with what was contained in the delegations of authority. Now, one of the issues that came up at the time was for me to be challenged around this particular delegation of authority that I have. So it was raised vehemently, by her, together with the group CEO at the time, Mr. Kramet Molepo, saying I did not have authority. And my response was, this is a document that comes from the board that indicates the authorities. It is not my document. But because that particular document was last approved during the tenure of Dr. Popo Molefe's board, this particular board, I guess, had not necessarily familiarized themselves, with the delegations of authority. That's why I think that the chairperson did not have an appreciation of the fact that she didn't have that authority to enter into the contracts.
But my question is whether you are aware whether she knew that actually there was in existence a delegated authority from the board in favor of the head of the legal department.
She knew, Chair.
She knew.
She did know, because she engaged with the document subsequently, yes.
She engaged with the document?
Yes.
At what stage was that?
It was during this process, Chairperson.
Prior to
the matters,
the
yes.
interdict and so on.
That's it, Chair.
And is that because you were in a discussion with her? That's how you know she knew of the document? Or is that because you were in discussion with somebody else who was in discussion with her, and based on that you know that she knew about the document?
It was Chair, I think the query was raised by the group CEO with me to say the chairperson wants to know where it is that you believe you get this delegation of authority from. So I knew at the time that they were discussing the issues around the delegations of authority. And for me, I took it that the interpretation perhaps is not understood in the manner that I had understood the delegations of authority. And so I knew that she had, wanted clarity around it and had requested the group CEO at the time, Mr. Kramet Molepo, to request me to explain why I believe I've got authority.
And you had explained where you believed you got the authority from?
From the delegations of authority, yes. And what I indicated, Chairperson, was this was a board document.
Yes.
It was not
I
my
accept that,
document.
yeah.
And also what I had indicated is that it is very easy, should the board take away that delegation, it was within their ambit to do
Yes,
so. But for as
yes.
long as it existed,
Yes.
then it meant that I was the person that was
Yes,
authorized.
yes. So your response to the group CEO was, I've got delegated authority.
Yes, in terms of the board of, in terms of the
Yes.
delegations of authority document.
Yes.
And I pointed
and
out.
he knew what you were talking about.
That's correct, Chair.
And did you subsequently have any discussion with him that suggested that he had conveyed this to the chairperson? What you had said?
We didn't have a discussion as such,
Yes.
Chairperson, but I'd written to him.
Yeah, you had written to him. Oh.
Yes, with the hope that he would
So-
transfer it
and-
to the
and-
chairperson.
So this was in an email.
That's correct, Chairperson.
Is the email here? One of the
I
documents here?
can also
You can
retrieve
get
that email.
it. Please get it. Had he written to you and you are responding, or had he just spoken to
He
you?
had written to me, Chairperson.
So please get all of that.
Okay, I
Yeah,
will.
yeah. So, but you would have expected him to then have either passed on your response to the chairperson
That's
or to
correct.
have told the chairperson of the gist of your response.
That's correct, Chairperson.
And so after that, but after that, still the chairperson continued to deal with the matter on the basis that she was the one who had authority.
That's correct,
And that
Chairperson.
you did not have authority.
That's correct, Chairperson.
But you never got to know what the basis was for that view.
No, I didn't. I mean, there was a point where I requested to have a meeting with the chairperson
Yes,
herself, and she just refused.
yes. Okay, thank you.
It-
So
it-
in other words, I'm sorry, Mr.
No, no.
Sons, are you able to say as you sit there that as far as you are concerned, there is no way the chairperson could say she was not aware of the delegated authority in your favor?
That's correct, Chairperson.
Yes, she might have some other contention, but not that.
That's correct, Chairperson.
Okay.
Now, Mr. Ngoyi, you may have said this, and I'm just trying to determine, when you talked to Mr., is it Molope?
Molepo,
Molope,
Mr. Kramet Molepo.
yes. It was he who was coming to you to say the chairperson wants to know.
That's correct, Chairperson.
Now,
In fact, if I
Sure.
may, Chairperson, Mr. Molepo came to me and said the chairperson was upset with the fact that we had interfered in a matter that she was dealing with. So she raised that annoyance with Mr. Molepo, and Mr. Molepo communicated that to me and requested that I then explain myself as to what the basis of my involvement was in the matters.
Did you, by any chance, attach to your response a copy of the delegation?
I did, Chairperson.
You did?
Yes.
Okay.
that was going to be my question, Chairperson.
Yes, yes. So let's get to that tomorrow, the complete stuff that you sent to the group CEO.
Now, there's a matter that I should have taken up. You indicated that the chairperson told the CEO that you must be disciplined.
That's correct, Chairperson.
And what were you going to be disciplined for?
Well, I don't know, Chair. I was waiting to see what I would be disciplined for. Maybe it was for not taking instructions, as I was told not to defend the matter on behalf of PRASA. I didn't know, but one thing I was certain of is that what I did was in the best interest of the organization, and I would have done it again, faced with the same circumstances. So,
Well, whether through circumstances or subsequent circumstances or for other reasons, you were not disciplined.
no, I was not disciplined, Chairperson. I think when the chairperson then resigned, the matter frizzled away, and it is what it was.
Now, let's just take the chairperson. She is appointed on the 17th of October.
That's correct, Chair?
At that time, She was a senior counsel.
That's correct, Chair.
Now, in terms of what was out in the public space, what was going to happen to her practice from what was in the public space in October?
Well, in the public space in October, Chair, we knew that she had been appointed as a judge, to act as a judge. To become a judge, not act, as well. So, you know, it was something that was spoken of. And we were looking, in fact, we asked ourselves questions around how possible is it that she could take on the chairmanship of the PRASA board when she's going to be a judge. So that was in the public domain at the time.
The announcement, well, I think it is common knowledge. The process that's followed is before a judge is appointed, there are hearings before the JSC. The JSC make recommendations, and then the president then appoints.
That's correct, yeah.
At the time Ms. Makubela was appointed to the board, had any of those processes taken place?
Chairperson, I think she had gone through the interviewing process and identified as a candidate. I think the last leg of it was where the president would then confer the judgeship onto her.
She then, well, before then, what was the feeling in PRASA about a person who's been nominated by the JSC to be appointed as a judge to take up the position of the chairperson of a statutory body, effectively an executive position?
We didn't understand it, Chairperson, because, you know, we saw a bit of a conflict, really, in that respect, to say, you know, she's going to be the chairperson of PRASA and she's going to become a judge. How is it going to look? Because the appointment had already happened, you know, and when I'm talking about the appointment before the president, you know, confers it on her. It was common knowledge that
the recommendation.
The recommendation.
It might be important that we get this right, because
the terms.
I see even in other sources it's misunderstood.
Yes.
The Judicial Service Commission interviews candidates, and then in the case of appointments to high courts, it advises the president who to appoint. That's the correct terminology.
Okay.
It advises the president who to appoint. And then there is usually a period between the time the JSC advises the president and the announcement by the president that he has appointed. So when the JSC advises the president, the candidate is not yet a judge.
Okay, sure.
And when the president appoints the person as a judge,
It's only there.
if the appointment is with effect from the date of the letter of the president, then the appointment is with immediate effect. But usually the letter of the president will indicate with effect from when the appointment would be. So you could have an announcement by the presidency that so-and-so is appointed as a judge, but with effect from a month from now or something like that. So there is that process.
Sure.
So, and the person can't start performing the duties of the judge, can't assume the job until when the appointment says this is the day from when they do that. Okay.
Thank you,
Yes,
Chair.
please,
Okay.
Chairperson. Ms. Ngui, can I ask you to please look at paragraph 51, because all these small issues, well, seemingly small issues, are quite important. So I'm going to ask you questions relating to the process that Chairperson has outlined. And where did you get this information in respect of paragraph 51 from?
Chairperson, as I indicated,
What paragraph?
Oh, sorry, Chairperson, paragraph 51, page 299
Okay,
of
thank
SSB,
Okay,
SS7B.
thank you.
Chairperson, it was, I think for me it was communicated. You know, we got to hear about it in the media, and I remember there was a time when Unite Behind as well, you know, had captured this and had started questioning the chairmanship of Ms. Bakubela. So it was something that was in the media that was communicated.
Well, first tell me what it is that you say in 51.
Oh, in paragraph 51, Chair, I just basically mention when the chairperson was nominated to be a judge, which was in July 2017.
That is before she was appointed to chair the
That's
PASA
correct, Chairperson. So in
Yes.
July already the nominations had happened. And then she takes up the chairmanship of the board in October.
No,
Yeah.
no.
In
Sorry, Mr.
October.
Ngozi.
On
Sorry,
19th of Minister.
and can I just do it in sequence so
Okay.
we have the
Yes.
correct order?
Yes.
She is nominated in July.
Yes.
When is she recommended for appointment by the Judicial Service Commission?
It's on the 4th of October.
Yes. Then when is she appointed as chairperson of the board?
On the 19th of October.
Now, two things would have happened in regard to that appointment. The first is the minister would have had to make the appointment. Would that be correct?
That's correct, Chair?
And he would have known that she's already nominated.
That's correct, Chair.
Well, one would assume he
One would
have
assume,
known.
Chair.
And she would have had to accept the appointment as chairperson of the board.
Well, I guess so, Chair. I mean, I'm taking it from the fact that the nominations had already happened. And,
Yes.
and then she gets appointed as the chairperson of the board.
Yes.
I don't know, you know, what his frame
Yeah.
of mind was at the time to accept the chairmanship when
Yeah.
the process of becoming a judge
Yes.
was in place.
But I'm just putting it as a matter of common sense. I am nominated for a position by a minister, and I say to the minister that I have a difficulty, I can't accept this nomination because I'm likely to be a judge in January. So in order for me to accept the appointment, I would have to indicate to the minister that there are no obstacles to my being appointed as the chairperson of the board.
That's correct, Chair. One would expect that happens.
Anyway, she is nominated or appointed on the 19th.
That's correct, Chair.
And you say thereafter, she accepted the appointment.
I'm
That's-
sorry, she's appointed as the last
Chairperson.
appointment you were talking to, is it appointment to the board or as a judge?
Oh, sorry, Chairperson.
We have two, there are two
as-
appointments, so we need to clarify
Yes,
which one we're
yes,
talking about.
Absolutely. She's appointed as chairperson of the interim board on the 19th of October.
That's correct, Chair.
Yes, okay.
And then you make a point about her accepting the appointment. Yes.
As the chairperson.
Yes, as the chairperson, yes.
Yes, she accepted the appointment because she came and became the chairperson of PRASA.
Okay. And you say that surprised you?
Well, after a while, when you start understanding, chairperson, what is involved, one would not have thought that, somebody who is really going to be appointed at the bench would want to still be involved in running a state-owned enterprise. It's just, for me, it was just common sense, but I guess we don't look at things the same way.
Well, we will hear. She will come and she will put her side of the story. But it does look quite strange.
Yeah.
That after she had been to the interviews, and she must have known soon after the interviews that the JSC was going to advise the president to appoint her. So if the JSC interviews were around beginning of October 2017, and she accepts an appointment as chairperson of the board on 19 October 2017 or thereabout, she would have known that her appointment was imminent. Well, I think many people would know that I've been a judge for many years. I've been to the JSC many times. I have no recollection of any president in the last 20 years or so who have rejected advice from the JSC to say so and so should be appointed as a judge. It's normally just happens. If the JSC advises the president, we found so and so suitable, appoint, we advise you to appoint, the president would just appoint. So it is something that one would look forward to how she deals with it, because if the interviews were in October, also it must have been that whatever appointment as a judge would or happen would likely to take place to be with effect from early in the following year, if not before the end of that year.
Yes.
So acceptance of the chairmanship at that stage under those circumstances is rather strange.
Indeed. Now, you then say that there was a particular date on which the presidency announced that Ms. Makubela had been appointed as a judge.
That's correct, Chair.
And what was that date?
It was the 2nd of November, 2017.
And when was her appointment as a judge to take effect?
The appointment was to be effective from the 1st of January, 2018.
Now, you then record that she deferred the appointment.
That's correct, Chair.
Until when?
Until the 1st of April, 2018.
2018.
Yes.
Is there any reason that you know of that she deferred the appointment?
Chair, I'm surmising, and I think for me, really, having seen what transpired during that period, in my mind, I believe that the chairperson wanted to see this particular matter through before she went to the bench. So that's my explanation of it, that she needed to finalize this matter, and before it was finalized, she was not able to leave. That is why, for me, I think that's why the resignation came in March, after the sheriff had attached and removed. And this is what I believe, that I guess maybe that she thought that her task is done, and therefore she can move on.
But what you think in this regard would not be consistent, would it be, with this matter involving a small amount?
Well, Chair, I don't know. Look, Chair, I think at the end of the day, I mean, one thing that I also, we grappled with, was this matter involved Mr. Mabunda. And Mr. Mabunda was somebody who was, known at PRASA, influential at PRASA. So when you try and put the pieces together, you then say this is yet again one of those matters where, you know, we have this particular person who knows exactly what's supposed to happen, but who is now going to be assisted, you know, again. And that was taboo for us, you know, to say, can the chairperson really come to Brasa only to have this matter settled because of whatever relationships that she had? We spoke about it, Chair, and that's how we saw it, because it was too obvious for us to say, you don't come into an organization in the circumstances where you've been appointed as a judge, as a chairperson of the board, and pick this particular matter up and run with it to its conclusion, and then resign when you think that it is over. So for us, it was just something that was obvious.
Well, I know, Mr. Soni, I think you said you would deal with this, but I'm quite interested in it as well.
Yes.
The question of what other business of PRASA the chairperson during her tenure was interested in, what other tasks or whatever, what other issues were dealt with by the chairperson or her board during her
I will
tenure.
deal with it right now, Chair. One of the questions you've raised is that in her short stay of 5 months, as you say at the end of paragraph 51, this is the one matter she dealt with.
That's correct, Chair.
Are there any other matters, disputes between contractors and PRASA that she involved herself in?
No, Chair, this was the only one.
How many meetings did her board have during her tenure? Are you able to remember?
I don't remember the exact number, Chair, but there's quite a number of meetings that the board was having. In fact, the chairperson also spent a lot of time at PRASA, using the office at PRASA, you know, on a daily basis. So the meetings were not quarterly, you know, as one would have thought in relation to board matters. You know, they would call special meetings, but as to the number, Chair, I wouldn't be able to say.
Well, she was appointed as chairperson of the board in October 2017, is that right?
That's correct, Chair.
And she resigned
In March.
in March, about 20-something, but with effect from the 16th, is that right?
The 23rd of March.
23rd of March. So that would be about, what, 4 months?
5 months.
5 months.
Yes.
5 months. Normally, in a 5-month period, in your experience, the boards at PRASA would have met how often?
Well, Chair, normally the first port of call would obviously be the induction
Yeah.
for the board, and
Yeah.
that you don't regard as
It's
a
a
board
new
meeting.
board.
Yes. And one of the meetings, at least that she had, was with the entire staff. But this was her, not the board.
Yeah.
You know, as far as the board was concerned, I guess they would not necessarily limit it to the quarterly. They would want to try and understand, you know, the business of PRASA before the first quarter is over. So invariably they would call meetings, Chair, at least in my experience, you know, not long after the appointment, and call a board meeting to try and understand and have executives explain to them what it is that they are doing in the respective roles that each one, you know, would be involved in. So it would not necessarily be a board meeting as such, but it would be the board trying to understand the business of the organization. So I guess it was not something that was surprising to see the board engaging, you know, often at the time.
Now, you have said, as far as you know, she dealt with this Yaya matter of matters.
Yes, Chair.
And nothing else, or not much else, is that right?
No, Chair. This was the only litigation or a disputed matter within PRASA that she had an
Yes.
interest in.
But you did say that she spent a lot of time in PRASA,
That's correct, Chair.
and one would expect that she would be doing something at PRASA.
Well, that's correct, Chair.
Yes, but when I asked you whether she concerned herself about any other matters, I wasn't talking simply about litigation matters. I'm talking about other issues that might have needed the attention of the board and her attention, as far as you know.
Yes, Chair. There were a couple of matters
There were
that she
other-
dealt with.
yes. that she dealt with.
That's it, Chair.
And the board.
Yes, Chair.
Yes, but in terms of litigation.
This was the only one.
But were there other litigation matters other than this one that were in existence during her tenure?
Many, Chair.
There were many.
Yes.
Did she show any interest in the other ones?
No, Chair.
When you say many, can you help give me some idea?
Yeah.
10 others, 20 others?
Chairperson, as we sit currently, PRASA has got litigations more than 100 cases.
More than 100 cases?
Yes, that it's dealing with. It's either suing or it's being sued.
Yes.
It's reviewing contracts.
Yes.
And so there's a lot of work that gets done within the litigation space at PRASA.
Was that more or less the number even at that time, or would you say it might not have been 100, but certainly not less than 50? Or...
Yes, correct, Chairperson. There was not less than 50.
So there were tens of other matters.
Yes, Chair.
Which were pending in courts.
Yes, Chair.
And these CIA matters were the only matters where she was in which she was interested.
That's correct, Chair.
Okay.
Ms. Ngui, if the...
I'm sorry, Mr. Singh.
No, please.
Just to tie, to complete this. In regard to, was the position that in regard to all the other matters, she didn't challenge your authority to represent PRASA and to instruct attorneys? She
didn't, Chair. In fact, if anything, after I had deposed to the Siangena affidavit, some of my colleagues, Mr. Chris Mbata, as well as Mr. Dumi Muhube, wrote to her complaining about, the allegations that were contained in the CIA contract. I mean CIA affidavit. She once again, wanted me to explain myself as far as the position of that affidavit was concerned.
But never in regard to all the other matters?
No, Chair.
And she was aware you would be dealing with them?
That's correct, Chair.
Yes.
Because also whenever we sat with the board, we would report
yes.
on legal matters
yes.
that the company was involved in.
And that would be in her presence?
That's correct, Chair.
And in terms of amounts that the other matters may have involved, were they much more less than the 56 million rand or so involved here? They
differ, Chair. Some amounts are small,
yes.
Some amounts are big.
Yes.
We've got like the 2 billion rands that we talk about, 4 billion rands. Others is hundreds of thousands, others it's millions. So they would vary.
But are you able to say, are you able to remember whether among the matters that you say she didn't show any interest, there may have been matters with much more
yes, Chair.
Amounts than 56 million?
Yes, Chair.
And is there a figure that comes to
mind? From about 100 million to
upwards?
Yeah.
But there was no interest?
No, there was no interest, Chair.
Okay.
Now, in regard to the CIA matters, she kept your section, legal section, out of the picture.
That's correct, Chair.
If she had done that in regard to any other matter, would you have been aware of it?
Yes, we would. We would, Chair, because when we deal with legal matters, we obviously are the custodians of all the cases. So invariably, anybody that asks anything would have to come to us first to say, what is happening in this matter, and we would have to advise. So if any other matter, but also the way we worked within the organization, Chair, was that everybody understood the role of legal within the organization. So if anybody would ask about a legal matter that was dealt with at a particular business unit, the person responsible for briefing legal at the time would then come to us and say, look, these are the questions that I've had to deal with coming from whoever it is. For instance, in this particular case of CIA, when the colleagues that had given evidence at the liquidation proceedings were asked to put their statements together by the chairperson, they came to us and they said, why are we being asked to do this? Why are you guys now all of a sudden, asking that we put this together for the chairperson? So they were concerned because that request was a request that was made obviously via the chairperson directly to those people.
Now, when the chairperson was appointed, the litigation between PRASA and CIA had been going on for some time, is that correct?
That's correct, Chair. In fact, it
some
started in
recollection-
2015, so we were sitting 2 years.
It had been going on for about 2 years.
That's correct, Chair.
And during that time, your legal department had been handling it through the attorneys.
That's correct, Chair.
When she then came and then showed interest in it and started playing the role that she played, and you say that your department was excluded, did she ever complain that maybe the legal department had failed to handle it properly, as far as you know?
She did allude to that. She did allude to the fact that she didn't think that we had handled this matter properly.
Yes.
She said that she believed that the matter could have been settled long ago.
Yes.
You know, but obviously where we were sitting, there was no need to settle because we didn't believe that we owed CIA.
Yes.
And Chair, I must say that as a legal function, we don't defend all matters that come our way. We weigh what the facts are and whether the company has got a good case to defend.
Yes.
We take them on that basis. And the
Yes.
instructions that we had received from the business units were solid, you know, as far as those issues were concerned.
But did she say in what respect she thought you had, your department had failed to handle this matter properly in her view?
She linked it to the liquidation process, Chairperson.
Yes.
And she said because our people, our colleagues had conceded in the liquidation process that we owed CIA, she believed that we had not handled this matter properly. But when we engaged with the colleagues, Vincent Kobuwe, for instance, Mr. Vincent Kobuwe, and asked what had transpired, but also Diale Mohashwa was representing us at the time, Chairperson. And even though they were not allowed to participate in the liquidation proceedings, they were there. And they could themselves come back to us and tell us how, you know, what transpired at the sessions. So, you know, when she came with that report saying a colleague of hers, you know, gave her this report and we made concessions, we disagreed with her, but she proceeded with it.
But as a matter of fact, were there any concessions that are relevant to settling these particular claims that had been made by your colleagues at
No,
the inquiry?
Chair. No, Chair.
And
They
that-
wrote.
And that you know that as a fact?
Yes, they wrote, Chair, because they
Yeah.
had to write to her
Yes.
and explain.
Yes.
And in their explanations, they do say
Yes.
that they did not concede.
And do you know whether once they had written, she accepted that they had not made any such concessions? You don't know.
Yeah, Chair, I think the way things happened
Yeah.
is that even though they wrote, I guess she didn't like what they wrote and wanted to proceed with settling the matter.
Do we have here in the bundle copies of emails or whatever statements that they wrote to us?
I can attach them, Chair.
You can get them
yeah, there's
for
quite a
us.
lot of information I
Okay.
removed from.
Okay, thank you. So she had complained that she didn't think that the legal department had handled the matter properly.
That's correct, Chair.
But as far as you understood her point, it was because she said the matter should have been settled.
That's correct, Chair.
Should have been settled because of alleged confessions that she said
That's
she had
correct,
been
Chair.
told had been made.
That's correct, Chair.
Okay.
Now, with regard to the cases, Chairperson, you asked how long they'd been going. Chairperson, if you look at DM4, and I'm not giving evidence, MN4 at page 3, which starts at page 322, you will see that the cases are from 2015 and 2016.
Yes,
Yeah.
yes.
That would give an indication of when the litigation had
Yeah.
started. Now, when Ms. Makubela resigned, what happened to the rest of the board members?
If I recall, Chair, some of them stayed and there was no chairperson. So it was an anomaly that existed at PRASA at the time. And I think for me, what I had understood from the minister at the time, Minister Blade Nzimande, was that, he was going to make his own appointment of an interim board again. So the rest, the board members, I think if I recall, one of the board members was then playing the role of the chairperson, and I think it was Dr. Skippers at the time, who was a board member who just took on that role. But at the time, again, chairperson, if you look at the composition of the board, it was not compliant because, there were other members that are required in terms of statute that were not in the board. So.
But had that been the position even during her tenure?
It was the case, chairperson. Okay. So, and there was a lot of attack coming from the likes of Unite Behind on the board that had been appointed by Minister Masongani to say it's not compliant with the Legal Succession Act.
Yes. Before Mr. Soni proceeds, I just want us to deal with this. You told me that the chairperson did say that she didn't think that the legal department had handled the CIA matter properly. What is your response to that criticism of your department?
I don't agree with the chairperson, Chair.
Yes.
I really didn't agree with her, and I made it known to her that I don't agree with her. Because in my view, and what had been reported to me, was that we have good prospects of success. So when she said that, I was taken aback, and I wasn't sure how it is that she could come in and within such a short space of time be able to make that assessment without necessarily engaging fully with the matters. So I just thought, no, I don't know what the chairperson is talking about, but I just don't agree with her.
Okay.
Can I ask you this? Sorry, Ms. Makubela left in March 2018, and the rescission judgment was granted soon thereafter. Would I be correct?
That's correct, Chair.
In regard to that arbitration, where is the matter sitting at the moment?
Well, I need to remind myself, Chair. So we were successful with the interdict, and we were successful with the arbitration, the rescission of the matter. I think that was the end of the matter, Chair, if I recall properly.
But all that was rescinded was the agreement.
That's correct,
or the award that was issued.
That's correct, Chair.
But the dispute, as I understand it, would continue to exist.
The merits of
the matter, yes. We proceeded with that, Chairperson, and
in arbitration.
Yes, no, in court.
Did you move from arbitration to court? So
remember, we had Part A and Part B, Chairperson, of when we brought the application for the interdict as well as the rescission.
Oh, yeah.
And then it also had to do with the facts surrounding, the conduct of the chairperson and how it got to us having had to approach the court.
Part A was the interdict.
Part A was the
What was Part B?
Part B was the rescission.
Rescission.
Yes.
Yes, but what counsel is asking is a rescission, once granted, all it would have meant is that the order of the court making the arbitration award an order of court would be rescinded.
Yes, Chair.
That would mean the arbitration award remains.
Yes, Chair.
Technically.
Yes.
As an arbitration award, as no longer as an order of court.
Yes.
So, in other words, the arbitration award is its status as an order of court is taken away.
That's correct.
So it remains simply as an arbitration award.
Yes, Chair.
Now, the question is asking is what happened after that? Was the award itself set aside? And if it was the original claims that had been pursued by CIA not pursued anymore?
Well, they did not pursue the claims.
They did not pursue.
They did not pursue the claims.
Do you remember whether the actual award was also set aside?
I can't remember if that
only
award was set
remember the
aside.
order?
Yeah, but I can't remember if that
Yes,
one
but
was set
they've
aside.
never pursued
But they didn't
anything.
pursue the
Okay.
matters, Chairperson.
Okay.
And it's 2 years since at least 2 years since the court order was rescinded.
That's correct, Chair.
And that, if I may point out, would go to whether the defense was a good defense or not a good defense.
That's
if they
correct,
haven't
Chair.
pursued it.
That's correct, Chair.
Now, you've finalized this part of your affidavit in relation to the CIA matters by pointing out that, in
before
fact,
that- Maybe before that, Mr. Sonny, was the rescission judgment by Judge Tifton?
Doctor, yes. Yes,
Is
Chair.
that the one for rescission?
I think yes, it was, that's
Yeah.
one. Yeah.
Okay.
Mr. Chairperson, we can make it available as part of the.
It should be part of the papers.
What, in relation to now Judge Makubela, what has happened as a result of all these developments that you've summarized in your evidence this afternoon?
Well, Chair, I'm aware that, a complaint was lodged with the JSC on the conduct of Judge Makubela. And I think for me also, coming from the decision of Judge Tuchten, which was scathing really on Judge Makubela, she obviously took exception to that and was challenging that judgment. And so where one is sitting now, I'm aware that it has been referred to the Judicial Services Commission, and this was referred by Unite Behind, hashtag Unite Behind again, and so I'm not sure where the process is right now, but I know there's a challenge.
Okay.
Chairperson, may I just make this point for completeness sake? So when eventually you are looking at everything, you would know what the various developments are. Following Judge Tuchten's judgment, in which he set aside the judgment granting effectively unopposed, granting the application unopposed, Ms. Makubela complained to the JSC that Judge Tuchten had raised matters in his judgment that ought not to have been raised. That matter was considered by the JSC, and there is a decision of the JSC. So we have all of that, and we
Yes.
will make that all available to you.
Okay. Okay.
That will just give you a complete
Yes.
picture of what's happened.
Okay.
But of course, as pointed out here, it is the complaint that Unite Behind brought against Judge Makubela that is now before the JSC.
No, that's fine. I think it would be a judgment or decision of the Judicial Conduct Committee,
It is.
which
Yes.
I think can be said to be a baby of the JSC.
Oh, yes. No, sorry to say. Yes.
Yes, but it's the Judicial Conduct Committee. Yeah.
Yes.
Okay. Is that where?
This is where
Are we
we're
done with this
in
part?
for this part.
Yes, yes. Okay, we are going to adjourn then for today. We will resume tomorrow at 10.
Okay. Yes.
We'll resume at 10. So we'll then continue. We adjourn.
As you.